Lord,
For upgradation and
Upon notice.
my Lord, may I take leave to move this application as an urgent listed petition, my Lord? Because my urgency is this, my Lord. The slope of the dam, my Lord, is used by the petitioner as their ingress. My Lord, petitioner's premises is adjacent to the Rubnaran dam. And my Lord, therefore, my Lord, they use the slope of the dam, my Lord, as their ingress and egress. My Lord, certain some stranger has constructed, my Lord, temporary structure. And my Lord, petitioner, my Lord, made a representation to the SDO. And thereafter, my Lord, they are going to, my Lord, concrete structure, my Lord. And therefore, my Lord, if it is not, my Lord, stop, my Lord, we will be
Please
suffer.
file and give the number. Concrete structure is not built in a day. Please file and give the number and consider.
But without any leave, my Lord, they will not take it.
They will take file. It should be a normal filing. Give the number. I'll consider. Leave is not necessary. Yes, next.
My Lord, either, my Lord, any day of the, my Lord,
Please
coming
give
week.
the number, sir. File and give the number and consider. What is it? No, this is the contempt matter. What is your matter? Yes, contempt matter, please give. For what? Why? Upon notice? Upon notice?
Five identical matters where land has been used without acquisition proceeding. I have some notice.
May I see one matter? My Lord was pleased to direct Lordship to this matter is today's Lordship, but on top, Lordship is specifically mentioned on top. But Lordship, this matter is running as item number 37, my Lord. My learned friend is in this matter, I cannot remember whether learned senior council Lordship, the causal basis is appearing in this matter. But in this matter, my Lord, this is the project Lordship, the relating to the Lordship Kona Expressway. As you mentioned for this matter, Lordship was kind enough, Lordship, allow me, Lordship, to file by affidavit in report on that last occasion, and Lordship specifically mentions the matter will come on top on priority basis. But Lordship, the matter they are enjoying this stay, my Lord, and Lordship.
It appears as a mention matter failure at the top.
My Lord,
mention matter
my Lord, if I may kindly.
Only indulgence, my Lord, only one indulgence, my Lord.
Yes.
My Lord, I was indisposed of. I went to hospital, my Lord. Doctor has advised me to at least voice rest for 2 days. I will do this matter, my Lord. Instead of today, my Lord, can it be taken up on Tuesday at top?
Up today. It's taking. I'm taking the mentioning today. It will appear next week.
My Lord, Tuesday, my Lord, if it is subject to convenience and if my learned friend, my Lord, I'm feeling uneasy.
Extension. The interim order is expiring today, I believe.
Yes.
Still the adjourned date, my Lord.
Yes. Well, that is mentioned, Lordship.
Interim order is expiring today. Kindly extend it till Tuesday, and Tuesday we'll do this matter.
Very good. It's a Tuesday. Mention.
I'm not kindly extend the interim order.
Interim order. Not in this matter. She was showing some other matter. It's not in this matter.
My Lord, this matter, my Lord had directed that the interim order is still the adjourned date. That is today, my Lord. It is in this matter also, so my Lord, technically it is expiring today. That is the difficulty. If my Lord kindly passes an order, my Lord, short order.
My Lord, if your Lordship kindly take listed on Monday, Lordship, and take the matter and tweet the Lordship on the Lordship. I have no objections on because it is
well till the adjourned date. That should be. Didi file to read. Interim order to ask expire for results.
Deeply obliged, my Lord. Deeply obliged.
12:30 first. I'll call it at 12:30 only for the extension. I'll call it at 12:30 only for the extension part.
Deeply obliged. Deeply obliged. Deeply obliged.
Deep voice rest. What is your urgency? What is your urgency?
My Lord, may I have your Lordship's kind leave to mention, my Lord, this matter which your Lordship last heard on 29th of January, my Lord. Lordship was kind enough to protect us till the adjourned date, which is today, my Lord. My Lord, my predicament is today the stay order that your Lordship has granted on the last occasion is expiring, my Lord. The matter is appearing in your Lordship's list as item number 603, my Lord.
Who is appearing for the respondents?
Mr. Day was there, my lord.
Please inform the respondents. I'll take it up at 12:30.
I'm so grateful.
For the extension part. এটা interim order
My
expire
lord-
করছে 12:30. Please inform the other side.
My lord, may I permitted to mention, my lord, for 5-year lease has been taken. That one is representation till now not considered. Upon notice, I am mentioning.
May I have a
With the
Give your-
flexibility, my lord, I am praying for lordship's benevolence, my lord. My lord, a contempt application is pending before your lordship. In that matter, my lord, I have applied for the certified copy. That application was made on 22nd of January 2024. My lord, if I can obtain that certified copy because the file is lying in your lordship's courtroom.
Oh, the file is lying.
Lying in your lordship's courtroom, my lord. I have applied.
Certified copy পাচ্ছি না উনি,
হ্যাঁ,
file টা আমাদের
I'll just because the matter I am. Matter is I'm told কবে আছে? The matter I'm told is returnable on 20th February. 20th February.
certified copy
Only for the purpose.
may I
I'm
have my
extremely grateful, my lord. Extremely grateful.
may I have my lord's kind leave to mention an item number 667. It is appearing under the heading mentioned matters. The urgency is that, my lord, my land has been occupied by the state government without due process of law. No notification under section 4(1) of the Land Acquisition Act has been given. No compensation has been awarded by the department.
already running in the mentioned matters list. I do not have any other list giving priority to matters. Please wait for your turn, sir.
May I have a lordship? Mention lordship, matter lordship relating to East Kolkata Wetlands Act. While lordship, the authority without serving any notice and without giving any opportunity hearing lordship, passed an order lordship directing me to restore the land lordship. Land has been changed its character since 1931. I have served notice upon the lordship state respondent. Lordship, the 7 matters are there lordship.
So many
Same
matters you
matter,
cannot
lordship.
take up like this.
7 matter lordship. We have already served notice.
You've seen this, the length of the mentioned
No,
matters
lordship,
list.
it's only lordship consideration order because no opportunity of hearing was
Give
given
the-
lordship.
give the numbers.
I-
Lordship,
May I mention, my lord?
I have
notice.
Yes, lordship. Mr. Day is appearing in 4 matter and other 2 matters, lordship.
Give
they
the
did-
numbers, give the numbers.
I have
My lord, I
indicated the
filed an
number.
application.
7টা matter আছে একসাথে রাখবেন 7টা।
My lord, I filed an application for recalling of your lordship's order because there is some mistake because state misleaded me that the direction has been made upon the deputy director of department, but actually they informed me that there is no post and that post has been abolished, so that part to be clarified.
Yeah, are you mentioning upon notice?
Yes, ma'am.
Lordship, may I permitted
The application.
যেরকম আসছে সেরকম দেবেন।
permitted to mention one matter. On 3rd February, I have mentioned the matter before your lordship, and your lordship was pleased to allow this matter, but this matter did not taken up in the list.
Not appearing in the list.
No, no lordship.
Are you mentioning upon notice?
Yes, lordship, I.
You have a lordship can
Yes, yes.
leave to mention one matter. This is not the North Bengal matter. My lord have checked and told us that my lord has determination. My lord heard this matter on several times. Now the matter is appearing. Item number 823. My lord kindly fix Monday at the.
Cannot fix matters like this, sir, in my.
Kindly give some upgradation. My lord, my clients are in the street for.
All the clients are suffering. Yeah, I can release the matter if you
No,
want.
my lord, kindly take up this matter, my lord.
It's not possible, sir, to take up matters out of list like this. It is a hearing matter.
Yes, my lord. I bring other side, my lord. Short matter, my lord. In spite order of this court, my lord, the entire demolition proceeding was continued, my lord.
Is it a hearing listed opore dike?
Lordship, may I be permitted to mention few matters who are already run?
Matters.
Yes, Lordship, these pertains to same subject matter, Your Lordship. These matters are running under the heading new motion. I'm only praying for inclusion of them under the heading mentioned matter, Your Lordship, because
Have you seen the length of the mentioned matters list?
Lordship, but all the
Motions will appear at the length. Why don't you mention next week?
grateful, Your Lordship.
Okay. Grateful.
May I have your lordship's kind leave, lordship, to mention one matter for upgradation, lordship. The petitioners are bedridden, lordship. They are in their advanced stage, lordship. The land has been acquired. No proceeding was there. No compensation was been granted
You're
in favor
mentioning
of it.
upon notice?
I have mentioned upon
Give it
deeply.
My
upon
lordship.
lordship.
I'm
Yes,
mentioning
yes,
upon
sir.
But this matter was mentioned, my lord, on 5th of January. My lord, sorry, my lord, 5th of February, but matter could not be listed because, my lord, on the previous mentioning slip, I did not, my lord, indicate the court in which the file is lying, and the writ petition is, my lord, in lying in RD. My lord, I have indicated lordship. Give the name, my lord.
My lord, as regard item number 377 up to date list, my lord. Upon notice, I am mentioning, my lord, the land, my lord, which was acquired by the BSF community, my lord, of the tribunal community, my lord, only land of the tribal, my lord. But they have not paid their compensation, my lord, till
Upon
date.
notice?
My lord, I have.
Yes, call the days list, please. All the three writ petitions are disposed of by a single judgment. I'm not audible.
Disposed of by a single judgment.
The writ petition has been allowed. I'll read out the relevant portion. Since the learned tribunal has decided the amount of compensation along with other benefits payable to the other owners, and the attempt of the state to challenge the said order in appeal was nipped in the bud by dismissal of the application seeking condonation of delay, the Land Acquisition Collector, Howrah, is merely an executing authority who is left with no option but to execute the said order in terms of the directions given in the order itself as well as by this court in the earlier orders. There was no scope for the collector to determine the issue afresh by ignoring the earlier orders. The writ petition is allowed. The Land Acquisition Collector, Howrah, being the seventh respondent herein, is directed to comply with the order passed by the Learned Tribunal in LA Miss Case number 23 of 1989 on 15th September 1989 within 2 months from the date of communication of this judgment.
Within 2 months, so
2 months.
2 months. Yeah.
Yes, next one. By a common judgment.
I'm for the state, my lord. May I submit the affidavit in opposition, my lord? Your lordship.
I beg to appear on behalf of the petition.
There is a direction for filing affidavit in opposition.
In opposition.
Yes, but there is an interim,
Hearing
my
order
lord.
today.
Yes.
It's a
The,
hearing matter.
my lord,
It's a hearing
No,
matter.
no.
upon exchange of hearing affidavits, my lord, it will definitely be a hearing matter, my lord. We are yet to be served with a copy of the affidavit in
Was there
opposition.
a direction for affidavit?
Yes, yes, my lord. In terms of, my lord, the last order dated 18th of December 2023.
Rajendra.
My lord, the second last paragraph. State is directed to
Yes.
file its affidavit in opposition within a period of 4 weeks after reopening. Reply 2 weeks thereafter. And matter to appear 6 weeks, my lord. Interim order extended হোক আপনিও তারপরে দিয়ে দেবেন যদি my lord permit করেন my lord, the interim order, my lord, is expiring, my lord, today in my computation, my lord. It was there, my lord, for a period of 8 weeks.
Right. Let it be extended for a limited
Yes,
period.
yes.
Affidavit in opposition submitted on behalf of the state respondents.
আপনাকে একটা
is on
copy
record.
অন্তত
But we have not yet been served with a copy of the opposition, my lord.
Serve here and now.
বাবা কত মোটা করেছেন
আর কি করবি 218 কথা পড়তে দম বেরিয়ে যাচ্ছে অ্যানেক্সটার গুলো দেওয়া আছে
Since no, the paragraph, the interim order
চোখ ধরছি
granted earlier is extended till 31st March.
That was
first March.
my lord,
Other orders?
reply in the meantime, my lord.
The order is till 31st March. I'll fix a date before that.
My lord.
Let the matter appear, let the matter appear under the heading hearing on, this is a group 1 hearing.
This is a land matter, group 1,
20th March.
20th. But reply in the meantime. My lord. Grateful.
May I submit the affidavit in opposition?
Please have recorded that.
It's too thick an affidavit for the state, my lord, to use.
There are
Great.
documents annexed.
Grateful to you. With your ladyship's leave.
Next.
My lord, I am for the applicant. My lord, last occasion, your lordship, please to direct me to file the exception to the report filed by the authority. I have only affirm is yet to do it. Only not today, my lord. Only
Not today.
with the approval of this thing.
This is a contempt matter.
Contempt.
Not today. Have you served a copy?
My lord, not
What is it?
after affirmation, I will serve my
For service affirmation is not required.
my lord.
For service affirmation is not required.
Yes, my lord. In course of the day, I will. Just I just
This matter, my
My
lord,
lord,
being on the state matter.
Yes.
my lord,
Yeah.
in this matter, there is also direction to file the exception to the report filed by the authority. My lord, I have collected all the documents, but out of 9, 7 has collected the correct paper. But my lord, 2 of them yet to collect the authority. My lord, kindly give some time to collect the some ROR.
May I submit one thing, my lord? In the last order, my lord disposes the writ petition with a direction for hearing, my lord, upon representation. Representation given by the petitioner was already disposed of, my lord. Five opportunities were given to the petitioners, my lord, for presenting documents, my lord. I have annexed all those time petitions, my lord, in my compliance report, my lord. 5 occasions they took time to file the documents, my lord, but they never filed the document, my lord. Now also they are submitting the same thing, my lord. Let this content be disposed of,
My lord, kindly
Leave may be
consider
granted to them.
one more chance. I am praying before your lordship.
5
Only
opportunities,
1
my
month.
lord.
1 month. My lord, it is true. Your lordships, please to give enough opportunity to me. Last chance. My lord, only last chance.
Learned counsel for the petitioner seeks further accommodation so that the petitioners who have not been able to produce relevant, who have not produced relevant documents before the concerned authority in support of their respective claims can produce the same. Stop. Paragraph, as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 11th March. Sufficient time, otherwise you miss
My
the
lord,
chance.
I'm grateful to you.
Next.
My lord, I submit on behalf of the petitioner led by Mrs. Rajashree Basu.
Have you served? Oh, it's appearing for the first time?
Yes.
So please serve the alleged contender and come back.
Okay. The content is that the Honorable Court, by the order dated 16 June 23 in WPA 9230/23, directed the third respondent, the assistant engineer.
Not necessary, madam. Serve and come back. Okay. Serve the copy of the contempt application and annexure upon the alleged contender and come back.
Okay.
The returnable date will be 14th March.
Next date, the 14th.
Item 9. Item 9.
So I am appearing on behalf of the petitioner. So this is first time. Yes, lordship.
Please serve and come back.
Yes, lordship.
14th March.
14th.
Item 10.
Lord, I'm appearing for the National Highway Authority.
Who is appearing? Petitioner? That's too late. Anyone for the petitioner in this matter? Are you ready? Who's appearing for the state?
On the last occasion,
Mr.
Lordship, Land Advocate Prosenjit Mukherjee is appearing, Lordship,
For the petition?
for the petitioner, Lordship. I'm praying for a very short passover.
Passover
I've
is not
just,
possible in this.
I've just received the brief, Lordship.
Passover is not possible. I'll grant you an adjournment, maybe.
Lordship. Then Monday, Lordship.
State, Mr. Mitro.
Lordship, Mr. Mitra is engaged in court room number 11, Lordship. Pleading for short passover.
Passover is not possible in this
Lordship.
case, sir. Please don't ask for a
He's
pardon.
there, Lordship. He's just coming, Lordship.
The state is not ready. You were supposed to file a further report in the form of affidavit. Are you ready with that?
Lordship, I have with me. Then I'm for the petitioners.
You're filing it today? Have you served a copy?
Yes. Yes, Lordship. I've served the copy.
Is it received copy of the you received copy of this report?
Lordship, the supplementary report.
Report.
Charake. No, Lordship, I have.
Are you filing it today?
Lordship, I'm filing.
This-
Yes, yes, yes. I received. So, Lord, I'm sorry. Now, Lordship, only one thing, Lordship, today, Lordship, this I have, in terms of the direction of earlier occasion, Lordship, the interim order was passed initially, first day. Now, subsequently, the interim order was passed.
Mukherjee, I think today he is not in a position to make his submission. Are you ready today? Yes.
Lordship, Mr. Mitra, I have to say.
I'll give you an adjournment.
Lordship, kindly, they are demolishing my property because till date, Lordship, even there is two, there are two plots. One plot, they are admitting, the two plot has been acquired for the purpose of development of National Highway. Under the National Highway Act 1956, this has been acquired. Now, Lordship, one plot they are admitting, this is Rayati plot along with the structure, but till date, the compensation of the structure has not been disbursed. So, compensation of the land has been valued, but till date not. That is also not. So, for the another plot is concerned, your Lordship directed them, according to them, this is a vested land. But till date, they have not produced any documents of vesting. And Lordship, that's why they have, Lordship, directed to file a affidavit.
They say it's vested under the 53 Act.
53 Act, but there is some proceeding is there. There will be recording, there will be notice to the landowner. There is no proceeding has been annexed.
Where are
Even
the documents of vesting?
Lordship.
Where are the documents of vesting? You've only annexed certain record of rights.
Lordship, in page number 7, Lordship.
that is the record of rights.
These are all record of rights.
Record of rights.
There should be a notice upon the riots, then whatever intermediate is whoever.
Lordship, that's why
Where
I'm
are these
saying.
documents? I mean, this affidavit is of no use to the case, I believe. We've not annexed anything to it. Since you claim vesting, you have to prove the vesting, isn't it?
Mr. Mitra,
Shall I
Lordship,
make it
I have filed an application for extension of interim order passed.
extend? When was it? When did it expire?
Lordship, this is expired. Lordship, kindly come to my application, can one.
There was no interim order all throughout.
No, initially, Lordship, on 9th February 23, Lordship, kindly come, order dated 9th February 23. The last portion.
It was extended lastly till June 30th, 2023.
Yes, 31st March. Initially, it is stayed 31st March 2023. Subsequently, it was extended till 30th June 23.
No, no, no. আপনার নাম দিতে হবে।
Till it was extended 23.
So after 30th June till date, nothing has happened.
So kindly, at least status quo should be maintained because they are trying to demolish my structure.
30th June, sir, we are in February 2024. 8 months.
Lordship, I have, as per your Lordship's direction, I have filed this application, Lordship, kindly for a limited period.
Let it be not today only, in that case. Come back on Monday. And please be ready on Monday. Will you take back this report because it has not, contains nothing?
Lordship, kindly keep it in the report, Lordship.
Because on this report, there will be an order in favor of the petitioner, let me assure you. A report in the form of affidavit not today. I'll just make it not today. Otherwise, it will again go down the list. এটা দিয়ে দিন, সোমবার দেবেন, not today.
But after the state respondent, not I have already filed my compliance report, not sorry, the report in the form of an affidavit.
I pray for extension of time for filing the exception. My lord, there are some irrelevant documents has come up in the report, my lord. But 2 weeks time be given.
Learned counsel for the petitioner seeks extension of time to use the exception to the report in the form of affidavit submitted on behalf of the state respondents. Paragraph, let the matter appear under the same heading on 14th March.
আমার কাছে রিপোর্ট আছে। আমি বাড়ি থেকে আসছি কি না আসছি তুমি জানো? এই হ্যাবিট গুলো চালু
তারপরে কথা বলি।
For the statement.
Petitioner? Anyone for the petitioner? What is wrong today? I do not find people.
Nothing is. Last time you lordship directed the petitioner to file an exception. We have filed a report, my lord.
None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the same heading in the monthly list of March 2024. Huh? Under the heading motion, Rajiv.
In this matter, I beg to appear virtually, but I am not well. But kindly make it not today only.
Not well, but you're in your vehicle. This.
No, I am going to a hospital.
I'm sorry, sir. I cannot consider your submission at all. Honorable Supreme Court is time and again deprecating this. None appears for the petition.
But I am appearing already in this matter.
Give your names. None appears for the petitioner, I said.
No.
Paragraph. Let the matter appear under the heading motion on 15th March.
My lord.
Okay.
14, I am for the petitioner.
Right.
My lord, Mr. Devashish Ghoshal appearing on 19. Morning he telephoned me that he is ill. He will not come. My lord, I am jointly praying that the matter may not be taken up today.
My lord, I filed that report as per and handed over the same to my learned friend, my lord. দিদি একটু দেন না এলাম তোমাকে দিয়ে দিলাম।
No, I am receiving the just now the copy of the report.
You want to use an exception?
Yes.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Petitioners, actually. Paragraph, let the matter appear. None appears for the 9th respondent. Let the matter appear under the same heading on 18th March.
18th March. Deplop like your lords. Not to নামটা লিখে দিতে হবে। এই নামটা একটু লিখুন।
মোশন
নামটা লিখুন।
ওটা একটু দেখে নেন।
But I'm the petitioner. In this petition, a resumption process was challenged. And lastly, on the last hearing before your lordship on 22nd of November 2023, I prayed to submit certain documentary evidence when your lordship was pleased to grant me leave to file supplement affidavit along with the documents essential for the better adjudication of the matter.
Yes.
But this is this supplementary affidavit.
You served
Dada, supplementary.
today.
Actually, no, my lord. Supplementary.
Do you want to go through this affidavit or shall we take up the matter?
আমি চাইছি mutation on the ground, on the basis of the probate granted by the court. Corporate তোমরা বলছো যে জমিটা ইনিশিয়েট রিসাম্পশন হয়ে গেছে
Petitioners.
কোর্ট জিজ্ঞেস করেছিলেন তুমি
আপনার নাম জয়ন্ত কুমার দাস।
চেঞ্জ হয়ে যেটা করতে গভর্নমেন্টকে জানিয়েছিলেন সেটা আমরা জানিয়েছি আজকে সেই সাপ্লিমেন্ট এভিডেভিটটা দিয়ে সেই ডকুমেন্টটা ফাইল করেছি।
জানিয়েছে বলতে my lord, that matter should be remand back to the authority as because he will see whether that is correct or not. How that
আপনি না আমি ডকুমেন্ট অ্যানেক্স করেছি
my lord,
আপনি ওখান থেকে
by the respective authority. My lord, I am not
I
the
think it would be better if you go through the documents and come back.
my lord, documents, my lord, it is
Not necessary to see.
because my lord, they are the authority, my lord, to see whether they file that thing there or not. If they file that thing, my lord,
আপনার তো কল্যাণ স্টেট ম্যানেজার
Kollan state manager বলেই তো that you will consider that aspect, my lord. If he filed that
I
thing.
think he has considered and turned down, isn't it?
Yes, my lord.
It was initially moved a writ petition. That writ petition was dismissed, challenging that an appeal was preferred before this Honorable Division Bench. Honorable Division Bench directed them to reconsider the matter. After reconsideration the case, they passed the impugned order of rejection that the resumption process is going on, but it has not yet been published in official gazette or the public newspaper. Challenging that, we have come before your lordship, and I submitted that the original lessee who died long earlier, thereafter one after another so-called notices and issued in respect to the dead person.
The indenture was not executed at all, is it?
Yes, least it was executed. Only they have that ground they have taken, the land has not been utilized. Plan was sanctioned, but when the plan was sanctioned, thereafter a few days, the original lessee died. His heirs and legal representatives approached to the authority that kindly submit the letter of so-called notice to our present address. In the supplementary affidavit, I have given that. If you'll also kindly take the supplementary affidavit which I have filed today. Page 5. This was submitted on 11 September 2012, and our present corresponding address they have given Mahakali Tala Lane, Basberia, Municipality, Post Basberia, such and such. Now the final order of termination was issued despite of having this letter in the year 2013.
So, my lord, they will consider and dispose of this matter in the light of that. If that is so, my lord, that order.
And I am covering by the judgment passed by the Apex Court and also by judgment of this Honorable Court, Division Bench of this Honorable Court, that I am entitled to get muted, entitled to be mutated on the basis of the probate granted by the court, because in the lease agreement there is a specific clause to that effect. If your lordship kindly see. But if you also kindly see,
That is not a dispute also.
not only dispute is that whether we have communicated earlier or not, and we have been informed about the date regarding the death of the original lessee.
So, my lord, they will consider this aspect and pass the reasoned order.
Where is the reasoned order that I have already passed?
Lordship kindly take
Page 58.
page 58. Second paragraph, only nothing to take trouble. Thereafter, has your lordship got it? Resumption process was initiated and the matter was communicated to the Director of Information, Government of West Bengal under memo number such and such on 27/8/2015 for publication. The resumption notice in two Bengali and English leading newspaper. Resumption notice for publication of resumption notice that has not been published as yet. And the present petitioner obtained the probate in the year 2015 by in PLA number 127 of 2015, which I have also annexed in the writ petition.
They have alleged violation of clause 2M.
Clause 2, yes. My lord, kindly come to the lease agreement. In the lease deed, sorry. My lord, clause 2M is there, no such clauses are there.
Page 15. Oh, no, clause 2(3).
Clause 2(3). That is, lordship will
Clause,
find
yes.
it at the at page 25.
Yes, that's the relevant clause.
At the cost of lessee within 30th October or such further time as may be good. But regarding utilization of the plot by raising construction.
When did the original lessee die?
2009.
This was within 30th October 1990. So you are in.
Yes, but the building plan was sanctioned after long year. Thereafter,
Did you seek extension?
no, my lord, that not. But lordship kindly take one page, very important page. When the present petitioner submitted the application for mutation on the strength of the probate, the authority directed him to submit all those documents in the year 2016. So therefore, my humble submission or my little understanding that if 2016 is this plot is alive, then the question of 2015 issuance of that termination notice in the leading newspaper, how it is possible, which has reflected in page 58.
Documents, 2016 document.
My lord, 2016, they have demanded all those documents. I have submitted on 3rd of October 2016, the very next page, page 44.
Of your supplementary affidavit?
No, writ petition. Main writ petition. Page 43. This is the letter issued by them to the present petitioner before your lordship.
This is in reply to which letter?
I have submitted an application for mutation.
Where is that application?
Lordship.
This is the document showing submission of your.
Kindly come page 45.
45.
No, sorry.
No.
I have submitted that letter on 26/7/2016. It is evident from their letter.
43.
Page 43. But presently, I don't have the copy. Probably I have not annexed. But just
16 it was considered.
It was the 16. It was alive.
Yes.
My simple case is this, my lord. If the plot is alive in the year 2016, and despite of having the letter regarding the knowledge of change of address in the year 2011-12, by the heirs and the legal representatives of the original lessee. It was submitted by the daughter of the original lessee, who came before this honorable court and deposed and gave the no objection consent during the process of the probate proceedings. Now, during that period of time, if your lordship kindly consider that
Where is the resumption notice?
this is the no such resumption notice was given.
When?
This is the impugned order.
Which is the impugned order?
Well, it starts from page 56.
Application হয়েছে বা?
No, in the year
My
2015.
lord, this is not complete resumption. So, my lord, after 16, my lord, that is 29/9, my lord, they will consider this aspect or all those aspects by the estate manager. If, my lord, that is not complete, if your lordship will see that 58 paragraph 2, and
Page
my lord
50.
16, that is 43, page 43, there is a contradiction, man. So, my lord, he will consider again on
So these
those two
show cause
aspects.
notices were not received by you at all.
No, never.
And if he filed
And it has not yet been published also in the newspaper.
in the year 2012, my lord, he changed it, he filed application before the authority
For
to
change
change
of
the.
address,
So,
yes.
my lord, he will fresh consideration, it should be fresh consideration in the light of those page 58 and 43, and my lord, there is supplementary with that.
But where was the notice sent? Is that there on record?
And the so-called notices were sent to the Bangalore in the year, firstly on 2009, thereafter 2011, 2000, thereafter finally 2013.
Is that recorded anywhere? That
Yes,
it was
it
sent
is
to
in there.
Bangalore?
It is in there. If you also kindly come page 57.
In this 57, my lord, that
Page
is also.
57, they have given the dates.
No, the address of the notice.
Return.
The first so-called notice in the year 2009. Lordship.
Yes, but where was it sent?
This is from their. I am submitting from their record. This is the impugned order which I have challenged. This has not yet been clear.
And that it was sent on the dead person also. Because
Yes,
the
2013 also they sent.
death of the lessee was informed. By the 2012 letter, let them consider. Mr. De?
Yes, my lord, let him consider on those aspects, my lord.
Until the disposal of their consideration, there shall not be any effect or a further effect to the impugned order, Lordship.
My lord, that already order is there, my lord, effect.
How
My
is
lord,
it
how-
not done?
My lord,
No
they will
so-called notice.
complete the same, my lord. Within
No
1
so-called
month, that
notice.
will be no, my lord. That is not as because, my lord, if there is in.
No, if the matter
year
is again remanded back,
2015, my lord.
again matter is if the record remanded back, they will continue with the hearing
they
process
file
on the basis of
and they
this
file this
impugned
application, my lord, in
orders.
2023. So, my lord, that part, my lord, your lordship passed the order to consider in the application in those aspects.
They have rejected the probate mutation.
Not so.
So this has to be set aside.
Probate mutation set aside.
This order
But
dated 12th April 2022 has to
that will be set aside, but not the giving effect to the original resumption order. He wanted to not to give effect to the resumption order.
No, I'm not. I'm praying for not to give an effect of this order.
Yes, my lord.
This order will be set aside.
Lord,
Because here your mutation has been rejected.
Lord, I'm obliged to you, Lord.
Order passed by the what are the counsels for the parties, huh? The order passed by the estate manager, Kollani, UD and MA department, Government of West Bengal, on 12th April 2022, turning down the prayer for mutation in favor of the petitioner is assailed in the writ petition. Paragraph. The predecessor in interest of the petitioner, Anil Chandra Rudra, since deceased, was granted lease in respect of a residential plot of land at Kollani, being number B-2/324 for a period of 999 years, with a deed of lease executed on 11 July 1963.
Lordship.
The deed?
No, deed was executed.
Your first paragraph says 11 July 1963.
September. That was the lease agreement. Lordship will kindly come, page 23. The indenture made on this 6th day of September 1990.
On 6th September 1990.
My lord, may I be permitted to take it?
The lessee expired on 25th September 2009. That's the date?
I'm given the death certificate also.
Stop. The lessee executed a will in favor of the petitioner during his lifetime, and by virtue of probate granted in respect of the said will, the petitioner stepped into the shoes of the original lessee. Stop. The petitioner informed the death of the original lessee as well as change of address of the petitioner from Bangalore to Hooghly to the authority by a letter issued on 11th September 2012.
Change of address of not the petition. Change of address of the heirs and the legal representatives of Anil Chandra Rudra.
Including the petitioner?
No, petitioner came into the picture after the probate. The probate was granted in the year 2016.
Yes, this is after probate. This letter was issued.
The change of address was issued in the year 2012.
And the person died in 2009. So it is after probate.
Probate was obtained after 2015. Dr. Kali, see the probate. Kindly come page 33.
Come, line. Bolun to ki bola beta. It was granted in 2016. 10th February 2016.
Yes.
By virtue of the probate granted.
In favor of the
probate. On 10th February 2016, the petitioner stepped. The petitioner stepped to the shoes of the original lessee. Stop the nokan. The petitioner informed about the death of the lessee. This is the 2012 letter.
Yes,
where the death and the change of address both were
address
involved,
of the heirs and the legal representative Anil Chandra Rudra.
as well as the change of address of the heirs of the original lessee, including the petitioner, before the authority by a letter issued on 11th September 2012, which was received by the authority on the same date.
Lordship.
Sometime in 2016, the petitioner applied for mutation in respect of the plot in question in his favor before the authority. Pursuant to which the estate manager, Kollani, by a letter issued on 29th September 2016, requested the petitioner to submit supporting documents in support of submit relevant documents in support of his claim. Stop. The documents were submitted by the petitioner on
3rd October
2016. The authority initiated resumption proceedings against the original lessee. The resumption proceeding was challenged before the writ court.
Initially, it was challenged. Initially they rejected the prayer of the petitioner regarding grant of mutation, which was challenged in the first petition.
What was the rejection on?
Rejection to that effect that your application for mutation is not, it can't be accepted because the land has already been forfeited. During the hearing of that writ petition, the landed state advocate produced the document challenging that we prefer the appeal.
But they have called for documents after.
But they have, but if you also kindly take trouble page.
Called for in
Hearing was taken.
2016. The writ petition is of 2021.
Yes. After long, there are.
So after this, it was rejected.
After this, an appeal was preferred. After the appeal court order, you'll also kindly see page 54, the hearing.
No, that is.
Page 54 is there in terms of the order passed by MAT.
Yes, yes.
And my lord, the resumption process they have initiated in the year after 2013, despite of knowing the fact regarding the change of address. And in the 2013 so-called notice was sent to the Bangalore address. It is evident from their impugned this order.
The concerned authority turned down the prayer for mutation submitted by the petitioner, against which the petitioner approached this court in a writ petition being WPA 6269 of 2019. 6269 of 2019. Stop. The writ petition was dismissed by an order passed on 19th July 2021. Stop. The said order was carried in appeal by the petitioner and an honorable division bench of this court, by an order passed on 27 January 2022 in MAT 1141 of 2021. disposed of the appeal, directing the concerned officer to take a decision with regard to the petitioner's prayer for mutation upon affording an opportunity of hearing to him or his authorized representative. So, in the meantime, the authority initiated resumption proceedings sometime in 2014. Paragraph. It appears, it is submitted on behalf of the petitioner that the notices of the resumption proceedings was sent to the earlier address of the original lessee, despite the authority being informed about the change of address by a letter issued on 11th September 2012. The resumption proceeding is still pending. Stop. The pursuant to the order passed by the Honorable Division Bench, the matter was taken up for reconsideration by the authority, who rejected the prayer of the petitioner for mutation by the order impugned, passed on 12th April 2022. Primarily on the ground of violation of clause 2 within bracket III small of the deed of lease by the original lessee. Paragraph. The clause 2 within bracket III of the deed is out, page 25. At the own cost, okay, framed for the purpose. Paragraph. Learned counsel for the petitioner submits that since sanction plan was obtained by the original lessee.
Yes.
When?
In the year 2008.
Only in the year 2008. Construction could not be commenced by the lessee before that. Upon consideration of the submission made on behalf of the parties, this court is inclined to believe that since notice of the resumption proceeding was sent to the earlier address of the original lessee, it cannot be said that it was duly served upon the lessee, more so, since the original lessee had expired prior to issuance of the notices. The order impugned was passed without granting an opportunity of hearing to the petitioner. So the petitioner was unable to explain the situation which prevented him from compliance with the relevant clause of the lease deed. before the authority. Paragraph, in view of the above, comma, the order in Q dated 12th April 2022 is required to be set aside. Paragraph, the writ petition being WP such and such is accordingly allowed. The order in Q dated 12th April 2022 passed by the estate manager Kollani is set aside. Paragraph, the estate manager Kollani being the respondent number,
Two.
being the second respondent herein, is directed to revisit the issue upon service of notice upon the petitioner and granting him an opportunity of hearing and pass a reasoned order within 2 months. In 2 months from the date of communication of this order, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week there. Disposed of, which
Obliged to your lordship.
Next.
Question, my lord, I am for the petitioner.
I beg to appear on behalf of the state.
The husband of the petitioner was the owner in respect of only 4 decimal of land, my lord.
Yes.
The public health and engineering department, my lord,
Stated here.
make construction on my land, my lord, without acquiring and without paying any compensation, my lord. I have made several applications before the authority, my lord. Since 2014, my lord, no step has yet been taken, my lord.
You're asking for consideration of the application?
Yes, my lord.
My lord, here this case is that, my lord, the land has been acquired in the year 1971. Gazette notification is there. Now, after a lapse of, my lord, so much decade, they made a representation.
Have you paid the compensation?
My lord,
Record is lying with me. In my
the record of rights may not be changed. My lord, the acquisition notification is there.
Did
Possession
you serve the notification upon the petitioner
my lord,
or her husband?
my lord, this is of 1971. And
Yes, so you have to show service of notice.
my lord,
Service of notice.
my lord,
Or rather
this is the my lord, the acquisition proceedings of 1969-61, and my lord, the gazette notification is of, my lord, of 1975. I have annexed the gazette
All
notification.
that is fine, but have you paid compensation?
My lord, that in instruction it is not here in the my lord, it is the, my lord, the very old. It is within the boundary of the PHE.
Your authority also says that the concerned BLLR has to explain why.
Yes, why the record of rights is in name? Why it is not corrected?
The fault of the authority and not the petitioner.
Well, dear,
The petitioner, being a layman, is not supposed to know. More so the widow.
well, let the representation be considered.
Yes, absolutely. Within 1 month. Within 1 month. And please pay compensation if you have acquired. That's their legitimate right, isn't it?
2 months. My lord, let it be 2 months because of, my lord, all the records of this is of 1970.
Page 14 is your representation?
Not page,
My lord,
15 is the, my lord,
extremely my
LA collector. Page 15 is before the LA collector, my lord.
LA collector, that will be, my lord, the
Page 15.
Page 15 is the appropriate authority. No, no, LA collector is to.
Page 13 is the district magistrate.
13 also.
Statement of facts submitted on behalf of the respondents is taken on record.
Collector
Then your lordship kindly direct the district magistrate to consider.
Page 13, my lord.
13.
District magistrate, my lord, who can look after the both BLR as well as the, my lord, both the recordings as well as the, my lord.
Page 13.
Very The petitioner contends that the plot in question, that her deceased husband was the owner of the plot in question. And she being the wife, and she has inherited the same after demise of her husband. The though the plot was acquired by the respondent authorities, no compensation has been paid to the petitioner for the same. The petitioner submitted a representation in this regard before the concerned authority on 4th March 2014.
Yes, my lord.
Will you file a fresh comprehensive?
Well, I have also
representation?
filed thereafter. I have also filed in 2023, my lord.
But not to the DM.
This is not very comprehensive.
It is not comprehensive.
Then your lordship,
And
I shall file a fresh
particularly
representation.
Fresh comprehensive representation stating all the details. Yes. This, as you can make out, it's not very,
Yes, my lord.
it doesn't contain all the details. But the petitioner seeks to submit a comprehensive representation ventilating her grievance before the concerned authority and pray for direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that the district magistrate,
Yes,
my lord.
that the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the third respondent within 2 weeks.
2 weeks, my lord.
Within 2 weeks from date. So the third respondent is directed to consider and dispose of the representation within 2 months.
Within 2 months.
From
From the date of receipt of
from
the.
the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Deep level, my
My
lord.
lord, affidavit service filing.
Instruction টা কি রেকর্ডে রেখে দিল?
হ্যাঁ।
রেকর্ড করে
তো ওকে দিয়েছে রেকর্ড
And for the petitioner, my lord.
Yes.
Well, as per the leave,
For the respondent.
as per the leave granted by your lordship, my lord, this is my exception to the opposition.
I am appearing for HIDCO, my lord. I am read by Mr. Abrutosh Majumdar, my lord. He is in some difficulty, my lord. My lord will kindly accommodate us, my lord, for the day, my lord.
My only difficulty is this, my lord, if my lord kindly recalls, I am not placing my submission for the time being as requested my learned friend. But if your lordship kindly recalls, when this matter was first taken up in the month of July, the HIDCO assured that they are not going to go for this particular plot of land. So far, the new notification for a draw of lots is concerned. Thereafter, my lord, they have filed their opposition. Thereafter, my lord, the matter was again taken up. My lord, in all those, my lord, occasions, they did not divulge that my plot of land is also, my lord, put on draw of lots. And perhaps, my lord, the allotee has been given as a successful, my lord, holder.
My lord, I'll have to take instruction in that regard, my lord. My lord, but we, my lord, on the last 2 occasions, my lord, they prayed for adjournment to file their exception, my lord. Our
That is
opposition was
another
filed in
aspect.
October, my lord.
Even before that, my lord, even before the matter.
The court is in session of the matter. You could not.
My lord, I have to take instruction to that regard, my lord. Even he has, my lord, assumptions, my lord, if that had been done or not, my lord.
No, I have.
He is apprehending, my lord, that the.
No, I am not apprehending. My learned friend is not aware. I have attached the copy of it, my lord. Kindly see with my exception, my lord. Written running page number 10.
Result of lottery.
And that is, my lord, prior to their filing of opposition. Even if I set leave aside their first day of, my lord, the hearing when the matter was first taken up.
This is 2B 487. This
Yes, my lord. This much information I have gathered.
it is their, my lord, bounden duty to, my lord, the assist the court
Pursuant to
whether.
Your lordship's direction, my lord, we had informed the client, my lord. My lord, I can assure your lordship, my lord, that this land has, my lord, most probably not been, my lord, allotted, my lord.
Very well, let it be recorded.
My lord, it is there, my lord, in the result of lottery, my lord, but the, my lord, physical allocation has not been done, my lord. I'll have to take specific instructions from the client, my lord.
I take it from the bar.
My lord, I'll take instructions from the client, my lord.
My lord, any
And I'll
reflection
instruct
in
them
the
today, my
order.
lord. I'll instruct them today.
Instruct them accordingly that when the
My
court
lord.
is assessing of the matter, they cannot touch this plot.
My lord, I'll do.
And only on their verbal assurance, my lord, was pleased to
Yes,
not to
yes.
record the any pass any written order, my lord.
I'm still on the verbal assurance. Please give necessary
My lord,
instructions to your
I'll
client. Exception used by the petitioners to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph. On prayer of respondent numbers which is 224.
My lord, respondent numbers 2 to 4, my lord.
224, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 7th March.
Well, any assurance may be recorded, my lord. The assurance of my learned friend
Lord,
may
I'll
be
instruct
recorded,
my
my
client,
lord.
Difficult if I record the assurance. He is appearing for the authority.
That is true, my lord.
Please give necessary
Lord,
automated.
Great pleading.
If anything happens in the meantime, please mention. I'll
My
take
lord, my lord, my lord, my lord. Deeply obliged, my lord.
1980, my lord, I beg to appear on behalf of the petitioner.
Yes.
Your lordship, my lord, can you see the last order that is on 24th of January, my lord, 2024.
My lord. My lord, Mr. Dey is appearing on behalf of the state respondent.
Have you received the copy of the reason or?
My lord, kindly.
Copy was directed to be served, sir. Nothing very great. You've passed a reasoned order. The copy needs to be served upon the person whose prayer you've turned down.
My lord, kindly with a 1 week accommodation.
My lord, kindly see the report which they have filed. On the last occasion, my lord, they have filed a report.
Let it be not today only. Please serve the copy of the order by the next date.
My lord, next to like.
19.
Not today.
Not today.
My lord, on behalf of the petitioner, my lord.
Yes.
My lord, in 2009 and 10, one land was being acquired under the Moja Ankurwati.
Is appearing for the Union of India? My lord, I'm appearing for the Union of India. Yes.
My lord, the land being acquired under Moja Ankurwati Domju in Howrah, my lord, in 2009-10. Now, of a sudden, in 2021, on 2nd of August, a letter was received by the petitioner, my lord, where he stated that now you come up before the authority and collect your award. Later, when they had gone, they have taken the award. 9,31,000 total amount was been given, my lord. Later, thereafter, my lord, one RTA was done.
One?
RTI, right to information, my lord. In the RTA, the reply was being made where they said a 3A notice under the National Highway was being issued on 3rd of July 2019. But actually, in 2009, the acquisition was started. The letter also which they received in August 21, it also stated the process started in 2018. But in RTA, they gave out the reply 3A started in July 2019. Thereafter, my lord, 3B, 3G, and all the information was given. And the award was being given in the month of September and October. Some more co-sharers were there in 2021, my lord. So that was a gap from the date of notification, 28 months. But the actual acquisition started in 2009.
Where do you get that?
My lord, it's there in page number 14, my lord. Kindly come.
It's their document.
Their document.
Very well. Yes.
The collector's document, the competent authority's document. Now, what has happened, my lord? There are two things which have been there in the award where have been lacking into. The section 30 of the 3 of the Fair Act 2013, my lord. The social impact has to be done.
where 12% has to be given from the date of notification till the possession or till the award. They should have been given. Now, things that they have calculated 12%, that is for a 20 months, only 20 months. But the acquisition started in 2009, madam. So, if the calculation has to be done, madam, that starts out from 2009 onwards, madam. And even I take out the notification which came out on the 3rd of July 2019, as per there, that also is 28 months, madam. The date of award which have been given. The second factor which I say out is the multiplying factor, madam. The multiplying factor depends on the distance from the urban, the rural area. This is the rural area. That is from 1 to 2 should have been calculated. They have taken the calculation as per 1, where it should be more than 1, madam. They never gave out a clarification. After 12 years, they served out a notice where they say out, you come and place out your documents where the process in 2018 has taken place and the award has to be collected, producing your identity card, madam. Kindly come to page number 14, madam.
Who is appearing for the state? No one, you have served.
Yes, madam.
There is a state respondent, I find.
Yes, madam.
Yes, madam. Respondent number 2 बोला, no?
No, 1.
No, 2.
2 is the district magistrate, madam.
Only not.
So may I request someone to appear? Mr. Botobal, may I request you to appear in this matter? State has been served. Yes, continue, please. Please serve a copy of the petition to him.
Now I'll help you.
My lord,
And your no.
No, continue with your submission. You can give it to him.
Well,
in
at page number 14, my lord.
Page 14?
Yes, my lord.
Yes.
My lord, the process is at the first, at the top. That's the letter issued by the district magistrate, my lord. The process is of 25th January 2018, my lord. Now, the date is 2nd of August 2021, my lord, where it says with reference to supplementary LAK 6 of 2009 to 2010 under NHAI Act, you are requested to appear before the undersignee on 12th of August 2021 at 12:30 p.m. Office of Special LAO G Howrah for collecting the payment of 9,31,800 against the area award serial number 55.5 in connection with the acquisition of land. So it was being issued on the first time we got it from after 12 years, my lord. Now, my lord, the page number 15 starts out their guidelines. That was issued by the Ministry of Transport, which says that how the things are to be given. In that, my lord, if we come to clause number 6, my lord, that is in page number 21, my lord. That is before clause number 6, 5.7, the relevant portion I'm reading, my lord.
5.7 or 8?
5.7, my lord. At page number 21, the relevant portion at the last part.
Yes.
There are 2 other issues that are related to payment of amount. Under section 33, the first is regard to the date from which this amount has to be calculated. Section 33 states that the date with the date of social impact assessment under section 4 of the RFCTLA-RR Act. However, section 4 is not applicable to the National Highway Act. Therefore, as was being done earlier, this amount may be paid from the date of issuance of the preliminary notification under section 3 of the National Highway Act. Now, they say out, my lord, I'm just interrupting into this. Now, as per the RTI Act, I'll show the RTI reply what they made it. They showed out the 3rd of July 2019, my lord. But actually, my lord, NHAI Act, which was being taken into consideration in 2009, my lord. The Highway Act that was being implemented in 2009. So the impact goes out from 2009 itself, my lord. The second issue is in regard to whether this amount is a standalone component or whether the same has to be calculated after addition of the multiplex factor and the solitium. The answer to this question is to be found in section 33, which clearly says that the amount is payable in addition to the market value of the land is calculated as percentage of the market value. This is a distinction between a market value and a compensation. Market value is determined under section 26. Section 27 provides the collector having determined the total market value with proceed to determine the compensation. The compensation is determined under section 28 of the Act. Therefore, a reading of the section would lead to the conclusion that the amount has to be awarded only in the market value. Now, they say this section 4 is not going to be applicable, but things are there. It cannot be made out in a solitary or a unitary value. It has to be taken into consideration when they say 3A, there is a part of the Fair Act has to be taken into consideration. Now, the multiplying factor, my lord, multiplying factor, my lord, 6.5 I'm coming at the next page, my lord, page 22, my lord.
Yes.
6.5, my lord.
Yes.
The DOLR notification 9 February 2016 prima facie appears to be inconsistent with the provision contained in the first schedule, especially in the result of the following 3 points. Firstly, it gives an impression through erroneously as if the central government was an appropriate government to notify the multiplying factor in respect of all central government projects across all the states. Secondly, it does not clearly state the notification was applicable only in relation to the Union Territory except Pondicherry. Thirdly, the perception of the MF of 2 points without correlation, the distance of the project from the urban area is prima facie inconsistent with the content of the first schedule. The said entry reads as under. Now, the table has been given, my lord, where the factor with the market value is to be multiplied in case of a rural area. Now, my lord, if I say one, they say out as per them, but actually it should have been 2, my lord. It is quite far away from the urban area. 1 to 2 based on the distance of the project from the urban area as may be notified by the appropriate government. This is the 2 things I have thrown out, my lord. Now, we made out a consideration in there. My lord, kindly come to the RTI, my lord. My lord, RTI we made out in page 45, my lord. After getting that letter, we made out an RTI where it was been asked, my lord, whether any notice under section 3A of NHAI Act 1956 in respect of the aforesaid mentioned case has been published or not. If yes, then supply a copy. Whether any notice under 3D of NHAI Act 1956 in respect of the aforesaid mentioned case has been published. Then we ask out 3E. Then we ask out 3G. Then 5 is whether any award has been passed in respect of the aforesaid mentioned case. If yes, kindly inform the date of the award when the award amount has been determined. Now the answer is at page number 46, madam.
Yes.
Mala, the notification under section 3A of NHIA Act 1956 has been published on 3rd of July 2019. Wide number SO 2294, 1st of July 2019. Then 3D was been published on 10th January 2020. 3E was published on 25th of November 21. Declared 3G is 26 July 21. And the payment is made on 26 October 21. So, as per there also, there is 28 months, my lord. Now, kindly come to my lord, the notification that was
2009.
Yes, my lord.
They don't say 2009.
No, my lord. It doesn't come into that. But the letter which was
that
letter says out. And it was also, we also know that in 2009, an LA case 6 number was started with under the NHAI Act, which they also admitted that the collector admit into that. But in regard to the information that was been given, 3A they issued on 2019. Now the notification is there in my lord, page number 48, my lord, where it says out 1st of July. It starts with the Hindi version and the English version is at page number 50, my lord. Page number 50, my lord.
Yes.
That is 1st of July 2019.
The 3A notification.
That's the notification under 3A. That is NHAI Act 1956, my lord. Even NHAI Act was been issued and later on, a confirmation on 9th of January 20, that is in page number 53, my lord. Now, my lord, the award is being stated in 56, my lord. The amount how I got out at serial number 55, my lord.
Yes.
Sufia Begum. Share is 538, my lord. The multiplying factor is 1.1. Before the land value, they calculated as 84,520. Later on, they increased to 92,972. The total came out here. The solitium was given as 100%. And 12 months, 12% can be seen as a 20 months, my lord. At the top, it's been given, my lord. 18594.
Yes.
And the payment was done out in the month of September, October. Maximum it was given in October, my lord. So we made out a representation on 22nd of November 22. Now in this petition, we asked out for consideration of our representation as well as the amount should be given as per the
That has not been paid as
not
yet.
been taken into consideration, ma'am.
This is a demand of justice that you have
We
issued.
made out a demand justice, that is the representation is there, Mala. Page number 58, Mala. We have stated the entire point into this, Mala. And we asked out the amount also. At the last page in page 61, we asked out the entire amount also.
Will you file a comprehensive representation? This is
Comprehensive.
the demand of justice.
Well, it may be. It's one letter was before been sent. Before the representation
not on record.
is not there, is not been placed out.
You have to include all the details in it.
That's been there, Mala. One more
Where
letter.
is it?
Mala, but the detail is given in the demand justice, Mala. It can be taken as a representation. It can be also be dealt with.
Demand justice cannot be taken as anything else but a demand justice.
But we asked her to pray, Mala.
Are you ready to consider the demand of justice? Yes.
Yes, if you will what's the direction, we can consider that.
Anything to add? They are seeking a consideration.
My lord, I am not only standing on his way, my lord, but my lordship can treat his entire writ petition as his the consolidated representation, if it's subject to lordship's consideration. Otherwise,
Shall I do that?
Your lordship can.
Yes, the Union of India, madam, do you have to add anything to this? Let the authority consider.
Only thing was their representation before the district magistrate. Kindly direct them to
That's what I suggest.
yes, my lord.
Yes. Including everything and before the proper authority.
If your lordship
It will be
directly,
sent from one table to another otherwise.
My lord.
your lordship, whatever
Yes,
things
what
are
like-
best fit. Whatever your lordship thinks are, because thing is there comprehensive is not there in the record, my lord.
Since you are there to instruct your client now, file a comprehensive representation.
Yes,
Let the authority decide within a stipulated time frame.
Yes.
Okay.
Madam, I'm serving the copy to my learned friend.
Copy of?
It has your direction, lordship. To serve a copy to the
Oh,
state.
yes,
Yes,
yes. Oh, you're serving it here and now?
yes, yes,
Very
now on.
My lord, one more thing, my lord, page 14, my lord, my learned friend, lordship, relying upon this page, but lordship, this land acquisition collector is required to be party, my lord. This land acquisition is not made as a party, my lord, in this
My
report.
lord, that is 2, page number 2, my
That is
lord.
the district magistrate, I think.
Is given land acquisition general department has been given, man. District magistrate and collector, Howrah land acquisition general department district level office building, my lord. So LA is already been made a party, my lord.
The district magistrate all the
Who will consider?
the special landing officer,
Special
Malad
land
Howrah
acquisition
general
officer.
is the authority.
That can be given in the direction,
Yeah.
your lordship.
Implement our-
Yes, your lordship can give it a direction to that.
On prayer of the petitioner, the special land acquisition officer,
General Howrah.
General, Howrah, be implemented as respondent number 5 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Since none appears for the second respondent despite service, Mr. Portable, who is present in court and usually represents the regularized court service. No further notice is service of further notice upon the added respondent is dispensed with as both the state authorities are represented. It is contended on behalf of the petitioner that the plot of the petitioner was acquired under the National Highways Act 1956, sometime in 2009 hyphen 2010, and the petitioner received a payment notice, and on receipt of a payment notice on notice issued on 2nd August 2021, the petitioner received such payment in reply to an application made by the petitioner under the Right to Information Act, 2005, the concerned authority, being the Special Land Acquisition Officer within bracket general bracket closed, Howrah, informed the petitioner that notification under section 3 capital A of the 1956 Act was published on 3rd July 2019, notification under section 3 capital D of the Act was published on 10th January 2020, possession under section 3 capital E was handed over to the requiring body on 25th November 2021, award was declared under section 3G of the Act by the competent authority on 26th July 2021, and payment made on 26th October 2021. Stop. The petitioner is aggrieved by the quantum of the award, since according to him, petitioner is lady, since according to her, such award was not assessed in terms of sections 26 to 30. In terms of
33 also, 30 subsection 3 also.
in terms of the relevant provisions of the Right to Fair Compensation Act 2013. So the petitioner seeks to submit a comprehensive representation before the before the fifth respondent, and prays for a direction upon the respondent to consider the representation at the earliest. Paragraph, learned counsel for the state respondent submits. Okay, upon consideration of the submission made on behalf of the parties, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the fifth respondent within 2 weeks.
Yes, ma'am.
Within 2 weeks from date. Stop. The fifth respondent is directed to consider and dispose of the representation within 1 month.
Okay, 6 weeks, some more time is important.
Within 6 weeks from the date.
Your Lordship can.
6 weeks from the date of communication of the from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, etc.
Affidavit not call for, my lord.
Usual words, record, usual line. But since no affidavit. Next.
Lordship, 29 for the petitioner, Your Lordship. On the last occasion, there is a direction to give a report by the state and the respondent authorities. I have received a report from the state, but I don't know how if they want to report. report কি দেবে তো? আমার copy দাও।
So when was the award passed?
Your Lordship, that the state has given a report, Your Lordship, but that is unsigned. Basically,
Unsigned.
yes. If Your Lordship see the state report, no.
Mr. Bondapathy, where is your report?
It's not dated. Kindly see page 11.
That is unsigned. Let me confirm with the
Page 11, Your Lordship, they have given a calculation.
It's not on record at all. The report has not come before this court.
জমা হয়নি সম্ভবত ওই কারণেই হয়তো হয়নি
Only one chance be given, madam. It will be on scientific.
Report in the form of affidavit submitted on behalf of the NHAI is taken on record.
Jacob Bulletin.
Paragraph, learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 13th March.
13th month. Madam.
21.
For the petition, Your Lordship. In this, I have received a report from the state, Your Lordship.
Same issue.
Same issue.
But I'm filing my.
I think here also there is no report. Yes, please file.
I'm filing my.
These matters are all similar, Mr. Bandapatha.
Sir,
Separate advocates are appearing, Your Lordship. They have appeared on the last occasion. In this matter, Your Lordship, Priyanka Shah and D. Dindar for the state.
Copy the law.
21, item 21.
Priyanka Shah, you are appearing?
Yes, for the 21.
Yes, 21.
Yes. This is what
You
have been.
find that only National Highways wanted to file a report, not the state.
Lordship, this is the instructions I have received. Lordship.
Come back with a report.
Lordship, it has been said that there is no. It's a civil in nature, and the police have filed. Lordship will kindly have a look at it. Yes.
It's a national highway acquisition.
Yes.
This is with regard to acquisition. What is civil in nature? Of course, acquisition is not criminal, it is civil.
Yes. So
But then-
party has been made. I'll get a detailed report.
Your Lordship, only one humble survey, if that can be indicated, what are the requirements? Because I have received the National Highway report. If Your Lordship kindly see once, page 3. Para 4, Your Lordship. Just I'll place this para for you. It says, after following the due procedure as laid down under the National Highway Act and applicable guidelines and orders as laid down by the Land and Land Reforms Department, Government of West Bengal, the competent authority, Land Acquisition Notia, that is the additional district magistrate LA Notia, respect number 7, had determined the amount of compensation payable in respect of the plots which were acquired in terms of section 3G1 of the National Act 1956. The compensation was determined under following the statutory provision of the National Act 1956 and the applicable guideline law. The next part is very important, Your Lordship. The total approved compensation fund as per the determination of the competent authority in terms of section 3G1 of the National Act 1956 in respect of all the acquired plot, structure, Moja, Shukpuria, White, LA case number such and such, was deposited by the P. Krishnagar NIC, White letter dated 31st/8/2015. So they're admitting they have paid after 2015 and the report says they're saying I'm not eligible for 2015 Act.
no, my lord.
Once they have deposited the amount in the year 2015, how can they pay me before 31st December 2014? 3G1. You have deposited the money in 2015.
Yes, Mr. Roy. How do you explain this?
And the report says I'm not eligible at 2013 Act.
Primary question was before or after 1st January?
My lord, in this case, my lord, it is not question of one Mosa lot. It is a question of the majority of the Mosa. My lord, here, my lord, I am ready to satisfy your lordship. Lordship, here only one Moja is not concerned. When there is a question of the majority of the Moja, then if the others are paid after that, lordship, they are also consideration within the zone of this the portion. So majority of the Moja is the most important part as per the guideline.
Majority of
The landlords
need to be paid.
not the Moja.
Not the Moja. Majority of the persons.
My lord, I am ready with this. The majority of the Mosa, lordship, the amount has been deposited. It is not the question of only one Mosa. So I am lordship, I am satisfied your lordship because
Yes, please do that.
Yes,
because
but
the
Your Lordship, only
condition
the
is majority of the awardees, not majority of the Moja.
Moja.
my lord, they as per the guideline, my lord, I will satisfy. I will satisfy.
Your Lordship, that's why only humble request before Lordship. Two questions maybe they may reply. One is if I participated in the arbitration and when was the award being passed and the copy of the award be placed. It will resolve the entire issue. The state has to give the award copy because NH has annexed the arbitration award but not the normal award. And from the arbitration award, I have never participated. Neither notice has been served upon me.
the award was declared prior to 31st December 2014. The petitioner is.
I have no case in this aspect.
My lord,
But
please
there
stop.
is there.
Maybe lordship leaves, but amount has been deposited after that. But lordship, in several cases, lordship, after the matter has been given back to the lordship, they have dismissed the case on the ground of this majority portion. Lord, I will satisfy lordship with this judgment or otherwise the guideline. I will say.
Will you come back with a report?
Yes, ma'am.
Report in the form of an affidavit submitted on behalf of the NHAI is taken on record. Paragraph, Learned Counsel for the State Respondents seeks to use a report in the form of affidavit. Paragraph, let it appear on the same date.
Yes, Your
My
Lordship.
13th, I said, 13th March.
Same date.
13th March. The issue is the same in all these.
Yes, my lord, issue the same.
Highly blamed.
Next.
Copy point. My lord, I am for the petition, Your Lordship.
Same issue, my lord.
Same issue, Your Lordship.
State,
My lord, receipt, but that is unsigned. I'm sorry, my lord.
Jayanto, same as
20.
20. The same date.
13.
But I am filing my report, my lord.
25 for the petition.
22
My lord, I have recorded as a target. Same law.
Yes.
Report in the yes.
23 is the one.
My lord, I
I
have
for the
state. 23 also you are submitting your report today?
My lord.
Who is appearing for the state?
Purpose. रिपोर्ट पे लिखे रहा मैंने रिपोर्ट भूल गया
You are for the state in this matter?
Tanay Chakraborty.
Yes, will you come back with a report? Do you have a report ready?
No, my lord. Report is not ready.
Will you come back with a report?
Yes, my lord.
Jayanto, it's same as 21.
My lord,
Same date.
21. Why 13 March? Did it? नाम तो करना.
24, Jayanto seeks to submit a report. Seeks to submit a report. 21. 24. Yes. Petitioner? New motion, no one. Anyone for the petitioner?
Showpiece. কি নাম আছে হেদায়েতুল্লাহ তুমি হ্যাঁ তুমি হেদায়েতুল্লাহ না তুমি মেরে না তক্তা করবে কত নম্বর আইটেম জানেন না নাম দিচ্ছে আপনি থাকার কথা
You're appealing petitioner? Shishir Kumar Ghosh, petitioner.
no
No one. None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the heading motion in the monthly list of March 2024. Five.
Well, Lord, I am appearing on behalf of the petitioner. Petitioner first is the land.
Appearing for the respondents.
Well, Lord, petitioner purchased the land in the year 2016. Thereafter, they got mutation from the BL and LRO. Thereafter, all of a sudden received the letter, unaddressed letter, my lord. This is the undivided land. Out of the 7 decimal of that particular person, we have purchased 6 decimal land. My lord. We have purchased 7 decimal of undivided land. My lord, thereafter, unaddressed letter from the BL and LRO, that highway authority, that is PWD, asked for the mutation about the recording their land in respect of their acquisition, my lords. That letter has been issued, my lord. Kindly comes to that letter. My lord, kindly page annexure P5, page 45, my lord. Asked to the Rayat to place the record relating to the ownership.
This is with regard to correction of record of rights.
Yes, my lord.
So this court may not have jurisdiction.
No, my
It's
lord,
under
that
the
is
block
not,
land and
that
land
is not
records.
the issue, my lord.
What is the issue?
That is not the Thereafter, my lord, some person raised objection relating to the undivided property, some person raised objection. That's why, my lord,
The PWD authority went there, surveyed the land and put forcefully, no paper has been shown, put forcefully the pillars there. And thereafter, the hearing has been taken up and the PWD's land has been recorded. My only 1 decimal land has been left out and the 6 decimal land has been taken up. We have wrote a letter to the
Taken
RTI.
away means it has been acquired.
Yes,
Acquired.
requirement. That is the acquisition. Acquired land acquisition.
Land acquired in the year 1961 with the name of the, and it has been recorded with the name of the PW.
Well,
Earlier,
we have asked for the previous owners also. They have not no knowledge of anything, so they have not received any compensation. I have also not received any
what is
compensation.
your prayer?
Well, not in adding portions, that is one mistake is that is not the changing, that is the recording the 1 acre land out of the 7 acre, that is 6 acre land out of the 7 acre lands. That would, well, all that is the impairing.
What is your prayer in the writ petition? What are you asking for?
Setting aside all my lord compensate.
How it can be?
No, I have not PWD, but at least that is my pair also. Kindly count pair V minus in alternate parts and award of the compensation in respect of the said part acquisition of the said land is being that is 6 that would be the 6 decimal.
Is a subsequent purchaser? You are a subsequent purchaser.
I have asked for that. They have not also received. We have made party to them also. Yeah. That is service affidavit service. But this is my affidavit of service.
Have you filed an application, a representation before the authority?
We have asked for the authority concern, that is a PWD, that RTI has been sent. On the basis of that RTI, the district magistrate forwards the concerned authority to reply that, but they have till date they have not replied that.
Why don't you file a comprehensive representation before the special land acquisition officer?
Madam, kindly
He is
consider
the authority to acquire, isn't
Madam,
it?
kindly consider.
Let him consider and decide the compensation.
Well, he has made a representation before the special land acquisition officer.
Where is
Page
it?
55. Page
Oh.
56.
Page
Page
56.
56.
That is
That
after
is reminder, that is the RTI reminder.
It's RTI Act.
No,
This will not the
That
court
is
cannot
reminder.
direct.
Make a complaint.
Let please file a comprehensive representation before
Let
the.
us consider this petition. I am.
No. There are a lot of things which cannot be considered in your writ petition. Yes, you have implemented the special land acquisition officer also as a party.
Yes,
So file an application before him.
kindly give that liberty.
Yes. Affidavit of service.
What item?
You are the co-owner, isn't it?
Yes,
Co-owner.
one of the corner.
The petitioner claims to be the co-owner of the plot in question and submits that a plot in question comprising 6.75 decimals by virtue of purchase, deed of conveyance, when did you purchase?
2016, madam.
Registered on 5th January 2016.
Yes,
On 5th January 2016. Stop. Sometime in 2021, the petitioner learned that the plot in question was acquired in a case number 10 of 1956.
যশোর তোমার অপরচুনিটি দিচ্ছেন ঠিক আছে
Stop. On inquiry, the petitioner found that no compensation was paid to the vendors of the petitioner,
এখানে অর্ডারটা লিখুন
far less to the petitioners. The petitioner seeks to submit a comprehensive representation before the concerned authority
ফাইল কোথা থেকে খুঁজে পাবে
in this regard and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondent submits that the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievance before the third respondent within 2 weeks. Within 2 weeks from date. Stop. The third respondent is directed to consider and dispose of the representation within 6 weeks. Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Item number 126, 126, that all together fall on same and us together, but somehow that has been.
Advocate কি আছে জানা নেই?
It's appearing for the state, I do not know.
Advocate কি আছে state এর সেটা জানা নেই?
I do not know who is appearing for the state.
26.
Lord, I beg to appear on behalf of the petitioner. Lord, petitioners, my lord, are the honor in respect of land,
Who is appearing?
which was, my lord, acquisition, my lord, under Act 2 of 48. My lord, the canal has been completed. My lord, the act also lapses, but my lord, no compensation has been paid to us.
Yes, Mr. Dhar.
There was an representation, my lord, dated 23rd August 2012. Let that be considered by the appropriate authority.
At page?
At page 48.
48 is social litigation officer.
Yes, will this be considered? Or do you want to file a fresh representation?
Well, there are also other representations which will appear from page 43 onwards. Lord, let a comprehensive representation be made.
That's why, because this is a very old representation. Why don't you make a comprehensive representation? It is submitted on behalf of the petitioners that though the land of the petitioners was acquired Vide case number LR 1982-83 under Act Roman II of 1948 for construction of a canal at the instance of the irrigation department, and such construction is complete, no compensation has been paid to the petitioners till date. Several communications made by the petitioners in this regard before the authority were not heeded to. Stop. The petitioners seek to submit a comprehensive representation before the concerned authority, ventilating their grievance, and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that the third respondent, special and acquisition officer, third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the third respondent within 2 weeks. Within 2 weeks from date. Stop. The third respondent is directed to consider and dispose of the representation within 4 weeks.
Can it be 6? Because election is
6
not.
weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. The decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of which attorney.
That has to be communicated within a period of
6 weeks. Communication within another 7 weeks.
Yes.
Next. 7.
Next is also same. We have served.
I am not appearing, but.
I'll request, let me see. Where's the service?
My lord.
If it is served, I'll regularize your report.
27.
27.
তুমি আছো? No, my lord,
You are appearing in this matter? Let the same order be passed.
Yes.
You've heard the earlier
Yes,
order.
yes, yes.
Affidavit of service, same order.
No, here below the comprehensive
Is there?
Page
Is there?
26.
Yes, so let this be considered.
Fine.
Yes? ওখান থেকে change করো। Several communications বলেছে না? ওখান থেকে change করো। ওখান থেকে বাদ দিও। হ্যাঁ? ওইটা করবেন। ওখানে করুন। না, ওইখান থেকে চেঞ্জ হবে। আর আগেও কি যা আছে সেম থাকবে। The LA case is also same?
No, LA case also same.
No compensation has been paid over that. The petitioners submitted a representation before the concerned authority ventilating their grievance
And accept PC.
on 26th June 2023, which is yet to be considered. Stop the petitioners, pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that the third respondent be directed to consider the representation in accordance with law. 2 weeks, 6 weeks, and another 1 week. So 6 weeks.
6 weeks.
Yes, yes. Directing the third respondent to consider the dismissal of the representation. 6 weeks from the date of communication of this order. Or communication 1 week. Pension matters.
বলে 12:30 আছে
Pension matters are.
If you are not takes up other matter, I kept 30 my lord.
30 onward, 30 to 40.
30 to 40 my learned for the petitioner. I am for the relay office. Your lordship director has to file a report, and they will file an exception. Only I am filing this report.
Matters are not called, sir. I'll take all of them on the next date. Please be ready with the exception also. I'll consider on the next. 6:33.
6
Sir,
I am for the. এটা না, এটা না।
No.
633 এসো। 633.
I তো
এগুলো মামলা হবে এসো। ওই ছেলেটি। এই স্যার আসুন। তোমার শাড়ি আসুন।
537.
আরে না হবে না, last হচ্ছে। My lord, your lordship, mention this matter, my lord, your lordship, this matter at.
5:37.
অন্যটা কল হয়েছে
For the purpose of extension of interim order.
My lord, only.
My lord, your lordship, dispose of this matter directing to set aside the order. If your lordship will see the order, that is a bad order by the DM.
No, sir. 537. Only matter.
537
Only
538
matter, sir. 537.
537.
তারপর
কত? 603. 603.
এরপরে
537.
537 টা করেছে।
No, sir. 537 is 260 of 2024.
My lord.
Yes?
My lord was pleasure lordship was pleased to fix the date on 13th February. My lord, in the last time.
Date is actually today. The interim order was extended till today. So I would like to extend it till the adjourned date.
My lord, only once, my lord, in the order, my lord, mentioned the canned one is not in the file is not in this record, my lord. If otherwise, let's on the next date, lordship, that will again.
For what is scan?
They can for the, I think, my lord, they filed like extension for the interim order. My lord, I think they filed this application for extension of interim order.
It is actually disposed of because it was extended.
Yes, my lord. Yes, my lord. But without.
Can event to এটাকে dispose of করতে হবে। Can 1 of 2023.
And I appear for my lord the petition.
Yes.
I think so.
Shall I adjourn it on your ground, Mr. Basu?
My lord, no, if your lordship wants to hear, my lord, I am ready with the matter. But the question is today, my lord, I did not get any opportunity in one court, my lord. I had to address their lordships. My lord, so today, my lord, if your lordship takes it up, my lord, on Tuesday and extend the interim order till Tuesday.
Right.
My lord, kindly recorded my objections, my lord. I am just objections for this extension, my lord. Otherwise, my lord, kindly, yes, my lord. Kindly record it, my lord. Not a single
My lord,
word.
she will be otherwise, my lord, she will be in difficulty if she says give
Yes, yes,
consent.
I am with senior. I am not on this.
No,
Yes,
no,
yes.
she has to protect herself. My lord.
Yes.
Learned counsel for the petitioner seeks extension of the interim order granted earlier till the adjourned date. Paragraph learned counsel for the NHAI objects to the said prayer. Paragraph, let the matter appear under the same heading on Tuesday's 12th. Oh no, I'm sorry, 13th February. On 13th February 2024. Paragraph, the interim order granted earlier is extended till the adjourned date. Paragraph, let me dispose of this can. It's for extension of interim order.
Yes.
Can 1 of 2024 is disposed of.
My lord, in this can lordship without being heard lordship, that has been disposed of without being heard lordship. If your lordship can record as an infractuous, my lord, I have not been in opportunity lordship to defend this can application, my lord.
Not required. It can be treated as days list and disposed of.
Yes. And my lord, kindly take this as a on a
The list. Why days list?
Oh, it is list in the list. Then it can be it is disposed of.
Application the last of it. This is the last, yes. একটা line add করুন তো ওখানে ক্যানটা ওখানে করুন since the application being can 1 of 2024 was filed for extension of the interim order on the earlier date, comma, the application is disposed of, comma, being infractuous.
my lord, kindly, my lord, I have to protect my. Yes, my lord. And my lord, another thing, my lord, kindly give us it on top, my lord, kindly, my lord, kindly give us the top, my lord. And if the my lord, again, my lord, the matter is come on the in the downgraded.
Mr. Basu?
Yes.
I'm so grateful to my senior.
Fairly at the top. There is another extension matter. Number?
603, madam.
603.
এগুলো মেনশন করেছে সকালবেলা
Private respondents?
My lord, private respondents, just now I have taken out a track report. It says, my lord, one of the private respondent have been served, my lord. The other private respondent has not been served. We have sent 3 sets of letter, my lord. One, the writ petition. Second, there was a change in.
So, Mr. Dik, it cannot be taken up like this. It has to be taken up serially in order as it appears. Let me extend the interim order.
I'm grateful. Yes, my lord, at the instance of the private respondent.
There will be some irregularity if I pass an order, if I dispose it of today, because service has to be complete since they are implemented. Will you complete service by next week? I'll fix a date fairly at the top since Mr. Dey concedes to the fact that it's not been passed in accordance with law. Yes.
Lordship, problem is that we have given 3 notices. Anyway, some postal.
All I have, my lord, all I have.
Copied with at least 15-20 days time.
Very well. I'll grant you some time.
I
It will be
again
adjourned.
entered things,
Yes.
appraise.
If you can only show service, I can dispose of the
My
matter
lord.
because the state concedes to your prayer.
My lord.
Yes, my lord. Early March, my lord. I will serve that. Again.
Service upon the private respondents is yet to be completed.
My lord.
Paragraph, since the interim order expires today. এটা দেওয়ার দরকার নেই। শুনুন, the interim order granted earlier is extended till the adjourned date. Paragraph, let the matter appear under the same heading on 11th March,
My lord.
fairly at the top. So that it can be disposed of
My lord.
fairly at the top. Fairly at the top. এটা আগেরটা দুটো সেম হেডিং। কিসে আছে? মোশন লিখে আছে।
I'm so grateful, my lord.
Motion is. Yes, now we go to the mention matters.
Oh, Reshma.
33.
I am appealing on with the petition.
Yes.
My lord will recollect, virtually the merit of the case has been heard. But on the last occasion, the question arose or raised by my learned friend for the state as to the maintainability of the writ application. My learned friend categorically stated that as a matter is pending before the LRTT, the matter should be sent there. My lord also expressed to that effect that it should go there. But I raised the point that land tribunal got no jurisdiction to try this case. But in support of that, I could not submit due to the scarcity of the time. Let me submit as to whether this court got the jurisdiction or the LRTT got the jurisdiction. On that point, I am to submit. Up to this has been left. Well, if my lord, after going through the brief, lord, if my lord satisfied that this court has got the jurisdiction, then I have nothing to say, save and accept the merit. But if my lords also accept the opinion of my learned friend for the state, that the land, this matter should go to the land reform tribunal, then I am to submit on the point of the jurisdiction of the land reform tribunal.
That was only because of the fact that in
Yes.
point 4 it is recorded that the matter will abide by the decision taken by any court, including
Yes.
the LRTT.
Yes, ma'am.
Yes.
Yeah, I abide, I bow down to that finding.
The matter is still pending with
So,
the LRTT.
so what should be done, according to my follow understanding, the writ application is to be kept pending here and or to be disposed of, directing the keep the order in abeyance till decision of the LRTT. Not if I go to the LRTT, they will refer their jurisdiction under section 6 of the Act. They would say, no, we don't have the jurisdiction to entertain this application. So, your lordship, can you allow me to place this point? You also kindly go through and will not allow me to place.
Today, this order, please give me a minute. The order impugned is 23rd November order. Specifically, it states that it will abide by any order which may be passed by the court or the LRTT. So let this order be stayed till
Yes.
disposal of the matter
Yes.
to the LRTT.
No, no.
Last order.
What step we can take? 91.
The LRTT may be requested to dispose of the matter as expeditiously as
Yes,
possible.
yes, that can be done. I agree to that effect. Well, I tried my level best. After having the brief recently, I tried my level best to mention the matter.
Yeah, if you find out they come to your on the micro
This court cannot fix a time frame for the LRTT. I can only request the LRTT to dispose of the matter as expeditiously as possible.
And in the meantime, the order is to be stayed.
It is because there is no other option. There is no other option because the order itself says that it will abide by the order of any court or LRTT. Order should not have been. I cannot fix a time for the LRTT. The division bench can.
Well, I am asking myself, well, I am a petitioner there. My learned friend is a respondent. If I don't take
Then
any
I
step,
will record
can
the
I be
submission
paid?
of the learned counsel that he will take all necessary
No,
steps for expeditious disposal.
And that
Yes.
too, two officers paper, one by the state, only by very good. You read.
And Mr. Dey, even if they are not interested, you are the other side, isn't it? The respondents there. Then the court cannot help. Then the court cannot help.
It has coming after one. Because I have a regular Mala in April, the past that order, I don't have it. I appear most of the cases where I know what is the order passed by our division and what they wait that order. Every time they overturn. But I am agreeable to that way. The interpretation may be present or dispose of directing
The order passed by the Additional Secretary to the Government of West Bengal on 23rd November 2023 is under challenge in the writ petition. By the said order, sanction has been accorded to long-term settlement of 1.65 acres of government vested land in favor of the Assembly and of God Church School, Raniganj, for a period of 99 years, with effect from the date of possession of the land for the purpose of extension of the school. Stop it. Clause Roman 4, small Roman 4, of the order indicates that, inverted comma open colon, if it is subsequently found that the subject land is involved in any court case in any honorable court of law, including WBLRTT, then all concerned shall abide by the orders as may be passed by such honorable court or WBLRTT. Stop, inverted comma closed. Paragraph. What is the matter pending before the LRTT?
That was without
The vesting.
No. Paragraph 17, my understanding is mistake. Very good, you put it out. As per the statement, paragraph 17, that is the statement of petitioner, that is the my learned friend has not carefully gone through the how do you get the time?
Paragraph. It is not in dispute.
I have handed over a bunch of data.
Yes.
You can see what was the challenge there. Challenge was by the special judge, set aside the order passed by the revenue officer in a highway and remanded back. Challenge the remand order of the special judge who defined appeal state का बनेगा but state has withdrawn our mandate. This is the case. Not PR case. There is no PR case till date. After decision of highway, PR case is to start. Automatic vesting that
5A is space vesting transfers, yes.
They came to municipal challenge by the same matter, because of High Court, and that was transferred to West Bengal and that is pending now, and that is pending. That has been allowed. That is pending. Give me that sheet. Now, I discussed my management. I have stayed in around.
It is, such details are not required also because it's pending. It is not in dispute that an appeal under the West Bengal Estates Acquisition Act. The appeal is under the Estates Acquisition Act.
No, appeal has already been allowed. LRTT is an additional application from High Court. That is in respect of the demand order passed by the special judge, whereby the order passed by the revenue official has been set aside, order passed by the higher official has been set aside and remanded back. We have challenged how many times a matter can be remanded. That was the challenge before the judge. Order has already been set aside.
It is not in dispute that a revisional application is pending before the LRTT. A revisional application pertaining to the plot in question, which was transferred before the WB LRTT by this court, is pending before the tribunal. Paragraph. Learned counsel for the petitioners submits that the petitioners shall approach the tribunal for expeditious disposal of the matter. Stop. Learned counsel seeks an order of stay of the order impugned till disposal of the revisional application pending before the tribunal. Well, upon consideration, application for revision application before the of the submission made on behalf of the parties, comma, this court is inclined to hold that in view of clause Roman 4, stated in the order impugned dated 23rd November 2023, directing all concerned to abide by the orders as may be passed by the court or the LRTT, comma, the order impugned is required to be stayed till disposal of the application by the LRTT. Paragraph. It is expected. The writ petition being WP is accordingly disposed of. Paragraph. The order impugned dated 23rd.
I think that might have as per RR. There is no two RR. There is only two RR.
This has nothing to do with the West to RR, Mr. Dev.
Pass the order to stable. The only part stay order. I am aware of that when the petition is not maintainable. How does stay order?
I have to discuss that the petition is very much maintainable because nothing has been challenged under the 53 Act.
And if my undertakes you would like to give the legitimate, if they pay, you are allowed that.
Even if it is not
Or
necessary.
after then,
আপনাকে পরে বলছি আমি শেষ করি এটা। The state till disposal করে বললাম তো till disposal of the application by the LRTG paragraph the state টা বলে I'm inclined to hold that বলে is required to be state বলেছি ওখানে it's required to be state বলে please wait sir. The petition is according to disposed of paragraph the order dated 23rd November 2023 passed by the additional secretary to the government of West Bengal is stayed till disposal of the application pending before the learned tribunal. Paragraph. The learned tribunal is requested to dispose of the application being, give the number.
being TA number.
Being TA number.
9. DA 9. 2169. 2169.
2169 of
2004.
Of 2004 as within bracket LRTT as expeditiously as the business of the tribunal would permit. এরপর there shall have been no rest cost আর ওই চ্যাটলাইন থাকবে যে মাঝখানে হ্যাঁ 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 থাকবে সব কথা থাকবে মাঝখানে একটু ঢোকানো এই পিটিশন সাফিসিয়েন্ট পরে ঢোকান এটা হ্যাঁ learned counsel for the state respondents have challenged the maintainability of the writ petition on the ground that it pertains to the West Bengal Estates Acquisition Act 1953. The writ petition challenges the order impugned which accords sanction to long-term settlement of land in favor of the private respondent. Stop. The matter in issue in the writ petition does not pertain to the provisions of the 1953 Act and as such, comma, the writ petition is maintainable in its present form and prayer. Stop. The connected issue is pending adjudication before the appropriate forum, being the WB-LRTT. The vesting part is pending there, not here. State till disposal of that. And I've recorded your submission that you will take necessary steps for expeditious disposal. I hope you followed this. I have recorded your submission also. Disposal. Next.
Notices has not been served. Mile kindly fix this Monday. Some notice has not been served.
Notice not served. Since service upon the respondents is not complete, comma, let the matter stand over till 14th March.
This is Monday.
You cannot dictate a date to the court, sir.
No,
Next matter.
I appear for the petitioner.
Amlan, motion, under the heading motion, I mean, same heading, under the heading motion, have a shop.
I appear for the petitioner. My lord.
Yes.
My lord, your lordship, dispose of the writ petition. My lord, by order dated 8 February 2023. Kindly see, your lordship, can 1, page 9.
For the applicants.
My lord, we were required to file a reply. My lord, twice, my lord, we.
You are the proposed intervener.
Yes. My lord, in our application for addition of party, they have used an opposition. My lord, we were required to file a reply. My lord, twice we took time on this, my lord.
Yes.
My lord, we will be praying for
Thrice
time.
they took time thrice.
We will be requiring time because certain documents, malad, the gazette notification, which we will be referring, malad, we couldn't be able to collect that one. And the nexus, malad, your lordship will see in between the malad, that particular officer and these petitioners, malad, whom I have called as land grabbers. Malad, they have made an application under section 6, and within 10 days, malad, entire office file was handed over to them. Malad, but we are requiring only one document, malad, that we are not even able to malad, collect. Malad. If your lordship asks me to make submissions on their my petition and their opposition, malad, I am ready.
Milord,
But so
kindly
far the
see your
reply is
lordship.
concerned, malad, I can make my submission orally, malad.
Want to come back with your reply? Do you need
Yes,
some
malad.
time?
Yes,
I can
malad.
give you some
Milord,
time.
this is the third time,
Yes, I'm
thrice they have
telling
taken
your lordship.
time.
Sir,
No, Milord, kindly see your lordship order. Kindly see once your lordship order. What I am suggesting your lordship. Your lordship order dated 8/2/2023.
I made this submission before your lordship, malad.
দাঁড়া
And
না,
the
আমাকে
reason I have
বলতে দে
also
না।
said.
Kindly see your lordship order. Your lordship directed to send the matter to the district land and land reform officer and to ascertain the Milord ownership of the petitioner. If they have Milord any case, they can Milord raise the point before the DLRO. Your lordship dispose of the matter like directing the DLRO to decide.
it has already been disposed of right
Yes.
by the DLRO.
And if they have a Milord, I am not opposing in their application. But if they have a case, they can raise the point before the DLRO.
They are not opposing my application for addition of party.
Yes.
Let it be, malad, let me add it as a respondent in the writ petition. I will come with an opposition.
In terms of an order of a division bench?
Yes.
Yes, malad. Malad, because malad,
they
they
have
want me
prepared
to
the
go
appeal.
before the authority. The nexus, malad, I have pleaded in my malad, application for addition of party also.
If they have a
Malad,
case,
they want
Milord,
me to
they
be
can
there.
raise the
But the
matter
issue,
before the DLRO.
how they have obtained an order from.
Do you agree
They are
to
not the owner. We are the owner, Milord.
do you agree to the proposal of the petitioners?
No, malad,
Is your,
malad, I want to make some submission and bring some document before your lordship, malad.
very well.
Milord, this is the third time, fourth time they are taking time, Milord.
How are you prejudiced, sir?
Milord, we are not taking the possession.
Is there
Property
any
is
stay?
owner, we are the owner.
Is there any stay?
My lord,
Is there any stay?
Lord, the direction is, Milord, to Milord, hand over the possession to the.
May I cut short the malad,
That is-
subject, malad?
That-
Malad,
Respected
the bill was malad vested
that
to the
is the-
state. It was
Not
leased.
vested.
Filed a contempt application. You have not.
Contempt application, Milord, your lordship dispose of the matter, they prefer the appeal. Appeal court, Milord, directed to add the part, Milord, addition of party and Milord, your lordship to heard the matter, de novo.
One more chance, malad, I will obviously.
Learned counsel for the proposed interveners.
Well, next week, Milord, kindly fixed it, next week, Milord, next week.
Not possible, sir.
Milord, we are Milord, suffering from 2023.
Of time to use the affidavit in reply as sought.
What are the dispose of
And this one not possible because next week is a truncated week.
Next week হবে না ভাঙা বেঞ্চ ভাঙা ভাঙা
Let the matter appear and the petition ready on 8th March.
8 March.
Great.
Please be ready by the next date.
Milord, this is the last chance, Milord. Milord, kindly record it, this is the last chance.
Come back with this.
last year পরে last time
Next.
last year
Next.
Chalo.
This is for extension of interim order. It was sought to be extended without filing an application. My lord's practice is that you have to file an application. That has been filed.
Application.
Yes. Application number table.
আচ্ছা,
Application number table. No. And 2 of 2024.
24 na 3? 4.
দেখুন sir. When did you file the application? It's not in the file actually. That's it.
Service is here. Affidavit service is here. It was filed on 25th January. Sumitra sis. খালি এক্সটেনশন করো আর কিছু করো হ্যাঁ খালি এক্সটেনশনটা করো
দর্শককে বলেই দাও না
বলে দিলাম তো
এক্সটেনশন করে না দর্শককে বলে যাতে দর্শককে বলবে করার কি আছে
এই
এটা অন্য ম্যাটারটা।
আমি অফিস করবো না
ইয়ার অফিস করার কি আছে
এক্সটেনশনের অফিস কি আছে
Order was passed on 29th August.
29th August. Matter appeared on the last occasion, my lord. I sought to convince my lord without filing any application.
But I was
But
not.
my lord, practice is you have to file an application.
Yes, since it expired sometime in September 23.
Yes.
Yes, Mr. Pondapat, let the same order be
Yes,
reimposed.
reimposed
Yes.
and fixed a date for hearing. The other application, writ application also pending. Let it come.
There are two writ petitions on the
Two
similar
writ
issue.
petitions.
Subsequent facts to be filed a fresh statement.
Jan 2 of 2024. All valid counsels for the parties. Petitioners seek extension of the seek reimposition of the interim order, which was granted by this court by an order passed on 29th August 2023. Or done at counsels for the parties. Paragraph, since an interim order was granted on 29th August 2023, restraining the state respondents from creating any third-party interest in respect of the plot in question, comma, the said order be reimposed till 31st March.
The matter, if it, I'll fix a date.
I'll fix.
Point is very simple. Notice on dead man.
Let the Let both the writ petitions appear under the heading motion on 14th March.
As you lordship.
Stand to discuss.
46.
Next.
The 637, my lord, is not yet heard.
This. They are together. There is an order of analogous hearing. There is no order passed in that matter. It is only tagged with the earlier matter.
My lord, 638, my lord, Mr. Devru Bhattacharya appealing this matter, man. But he's on his legs on in court number 34, man.
Petitioner,
Petitioner.
miss a chance. Have you served?
My lord, perhaps the report has been filed by the state, my lord. In respect to that
But
subsection.
there of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the heading motion on 15th March.
15th March. My lord, cannot appeal before 15th March.
Not possible. February is a short month. Next. Yes.
No, my lord, I should be candid before your lordship. My lord, at this stage, there is no scope for any interim order. Because I have challenged, my lord, the reason order pursuant to the order passed by your lordship. Therefore, there is, my lord, no scope. Your lordship can direct, my lord, for filing of applications.
Is it required? What is the, yes, you are appearing for?
Manoj Malhotra is appearing for the state lordship. He is not present today, lordship. I have the instruction, but kindly fix it any other day.
File it.
নাম দাও কি কি গাঙ্গুলি ভুলে গেছি ওই দীপান্বিতা গাঙ্গুলি দাঁড়াও আগে ও অর্ডারটা দেখবো তো
No, my lord, the order passed pursuant to your lordship's order at page 29. It starts from page 29.
Land loser's certificate. She is not prepared today. Let them come back. On prayer of the respondents, the matter.
My lord, I candidly said, my lord, there is no scope for any interim order because the similar person.
But the copy of the report, lordship.
Let them file the report. I can take the exception also. Because, my lord, they relied upon a circular, my lord, that circular is not with me. My lord, let them supply that circular.
Sir, kindly fix it in Tuesday, Lordship, I will serve. So shall I make it not today only? Yeah, Lordship. Yes, Lordship. Yes, sir.
As your lordship.
Not today.
Not today. No, it may happen also in my case also. Sometimes, my lord, we are unable to.
But there is no copy.
কি করবো not today তো আর কি দেবো ছাড়ো deeply হবে 1911.
But I have served them.
My lord, can he file the report, my lord, in the form of an affidavit
I've
upon a
just said
copy?
not today. Why do, yes, she can serve a copy to you today itself. It will appear on Monday again. So please serve an advance copy if you can. If it service,
But I have served one predicament. It was sent long ago.
I'm appearing for the state respondent only, Lordship. There are several private parties are also there.
Yes, yes.
I would like to see the service.
It was sent, my lord, on the long ago, November,
Do you want to serve and come back?
September, perhaps they have received because no letter has come back.
You have to file the track reports also.
The track report, now it has not received by me now.
Please come back after service.
I have served the only service of notice. Copy I have served.
Where is it? Show me the track reports, please. The track reports.
Track reports are not available.
It's not service.
So I will inform that matter. It
No
will be
need to serve afresh. Track report should show service. Since service upon the private respondents is not complete, let the matter appear under the heading motion on 15th March.
15 March.
Please complete service and come back.
Yes.
Next. 41.
I am for the petitioner, but I am paying not this recall.
That they record kar diye.
Mentioned matters, no, if you miss a chance, it's gone.
But I am not mentioning, my lord. Mentioning other side mentioning.
These are mentioned matters. Who is appearing for the respondents? Mr. Dev? It came up on your mentioning.
My lord, other side mentioning private party, my lord, mention this matter, my lord.
Who is the
Suddenly,
other side? Let me see. They can quickly mention for us.
Notice দেয়নি
no notice.
ভালো ভালো নোটিশ দেন
But I am not mentioning, my lord. Kindly, my lord.
Advocate for the respondents.
My lord,
Who is Mr. Narendranath Maiti?
but
He has moved the matter.
There are so many private respondents.
my lord. I am for the petitioner, my lord, kindly fixed a date.
None appears for the private respondents.
My lord.
That go out of list because none mention matter, nobody mention.
It will go to the normal list.
My lord, normal list, my lord.
On prayer of the petitioners, the matter is adjourned. Let the matter appear under the heading motion on 20th March.
20.
Next.
My lord, in this matter, I am appearing on behalf of the petitioner, my lord. The fact is that, my lord, the private respondent filed
Appearing for
initially.
the, state, Mr. Dev.
My lord, may I file my affidavit of service, my lord? My lord, the fact is that initially private respondent, being the owner of a property, filed a writ petition that in airing us as the private respondent in that writ petition for the prayer was that we are encroaching a private road, a government road. That is the highway I have encroached.
State highway.
Yes.
Yes.
And that's why your lordship passed already a direction, which I have annexed here. Kindly come into, my lord.
Page 25, yes.
I'm just giving, my lord. Page 25 and 26. This is your lordship's earlier order, my lord. What happened next? After that, there were some inquiries happened, and thereafter, the impugned notice. I am placing the impugned notice, my lord. Kindly come into page number 48. It is the impugned notice.
48?
Yes, my lord. Issued by the Assistant Engineer, PWD, Holdia Construction, Subdivision 1.
10-1 notice, yes.
Yes, my lord. Now, what happened, my lord? Kindly, I want to draw your lordship's attention to the third line of the subject.
Yes.
That is plot number 2253.
Yes.
My lord, now my lord, kindly come into page number 43.
Just to plot number 2253. Yes.
2253. I want to draw your lordship's attention. Now kindly come into page number 43 and 44.
Yes.
2253 is this is actually a Dage Totho. Here, my lord, what happened? 2253, these all persons are the owners of the property under that the particular Dag. Now, the private respondent's name reflected here as number 3, Ola Shaw. He is the private respondent.
Yes.
Now what happened, my lord? Kindly come into page number 49. 49 is the Dag which is acquired by the government. That is a road. And finally, my lord, I want to draw your lordship.
Or not, sir? Please
No.
tell yes or no.
Now, my lord, the story is that if I am encroach the road, this particular government machinery can evict me, can demolish my unauthorized structure. But if it is fall under the private land, this particular machinery has no authority because civil court is there. Now, my lord, what my learned friend is actually trying, he is actually trying to evict us from his personal property utilizing this particular government machinery, which is not at all permissible, my lord. That is my point, my lord. If an inquiry may be conducted by the authority fresh, then my lord, whatever and report be called for by your lordship, then whatever actually the right thing or right, that will be clear before your lordship.
The notice clearly says that you are occupying 2279. So if you are not really occupying 2279, you have no difficulty. at
Yes,
all.
my lord.
So why are you apprehensive?
My lord, why I am saying so, my lord, this particular Dag, I am not placing any another Dag. I am only on particular this Dag, 2253.
PWD road.
My submission is that we are occupying 2253, not any owner, any.
The authority is not concerned at all.
Yes.
And this is a 10-1 notice. Under 10-3, you'll be given an opportunity of hearing.
Yes.
You can place all your facts before the authority.
Yes, my lord.
So writ petition has to be dismissed.
Yes.
There is no ground. Right?
At least, my lord, let a direction be given to send us a notice, particular notice, my lord.
It has
Send us a
already been
notice.
sent.
Yes, yes, yes.
It has already been sent and further
Yes.
notice will also be sent.
Yes, my lord.
Section 10 says so, isn't it?
I am obliged, my lord.
Affidavit of service. You are for the state.
I am for the private respondent.
State?
State is.
You're for the state. Dismiss, Mr. De. The notice issued by the assistant engineer, PWD, Holdia Construction Subdivision number Roman 1 on 29th August 2023 under section 10(1) of the West Bengal Highways Act 1964 upon the petitioners is assailed in the writ petition. Such notice was issued by the authority pursuant to an order passed by this court on 16th August 2022 in WPA number 4278 of 2022. Stop. In the earlier writ petition, the private respondent herein alleged unauthorized construction made by the petitioners herein by encroaching upon a portion of the PWD road. Stop. The notice impugned directs the petitioners to vacate the unauthorized occupation on the PWD land being plot number 2279. Stop. Paragraph. Learned counsel for the petitioners submits that they have not encroached upon any portion of plot number 2279 and have raised construction in their Gayati plot being number 2253, you said?
2253.
2253. Stop.
My lord, here specific finding of the authority is there that they have enforced, my lord. This
Authority will decide. Huh?
I have.
Paragraph. Since the notice under section 10(1) of the Act has been issued with regard to unauthorized occupation of plot number 2279, which is PWD land, comma. The apprehension disclosed by the petitioners in the writ petition, as well as the writ petition itself, is devoid of any merits and is liable to be dismissed. Paragraph, in view of the above, the writ petition being WP such and such is dismissed. Paragraph, the since the order impugned was, since the notice impugned was issued in terms of an earlier order of this court, comma, the concerned authority, comma, being the, who is the assistant engineer herein?
Assistant engineer, my lord, Holdia Construction, subdivision 1.
STO, my lord. Is now in session of the matter.
The seventh respondent herein, comma, is directed to take the proceedings under section 10 of the Act of 1964 to its logical conclusion as expeditiously as possible, comma, preferably within a period of 2 months
But
from the
they
date of
already-
publication of this order. Because the date of the earlier order is over, I think. That is expired.
No, but as per my lord, your lordships, that order, authority already taken steps and they already referred this before the SDO for eviction. Already those steps have been taken.
17 is the date
Oh, as expeditiously, logical conclusion.
Now SDO is the authority, my lord, for the purpose of eviction.
As expeditiously as possible.
Yes.
I'm not mentioning any date in it.
Yes, yes.
There shall have been orders to costs, since no affidavits are certified.
I'm obliged, my lord.
Contempt application 751.
In this matter, I am appearing on behalf of the petitioner. But today is the first time. So,
Yes.
kindly direct.
You're asking for adjournment?
Yes. No, I am appearing on behalf of the petitioner.
Yes.
Yeah, press content. Yes. First time.
So please serve and come back.
Yes.
13th March.
Man.
Group 7 motion 752.
So I am for the writ petitioner in this matter. He was pleased to take this matter on 9th of January 2024. Lordship will see the order. The order is very specific because my prayer is that I have commenced my business from a certain date, which is being disputed by the railways.
5 stalls?
Yes.
Mala, I am for the Mala respondent Mala.
Yes.
I am outstation Mala, Delhi Mala. So kindly take it up Mala,
You are submitting virtually. You can continue your submission.
because I am not ready because paper is Mala Calcutta Mala. I am outstation Mala. So kindly take it up next week, any date Mala.
Next week, Lordship has fixed many matters of mine, my lord. Then Lordship,
Within
I am in.
first week of March,
Lordship has
kindly.
protected me from termination as because I am making payment on a regular basis. Now that has
As
not
far
been
as
disputed by the
transaction is
railways.
concerned,
Now the only document which was required to be produced before your lordship is that they have to demonstrate that they have handed over the stall prior to that date. Now,
Yes.
lordship, they nowhere in the reports. Two reports were filed as
I have
request.
all documents, my
The
lord.
matter today because learned counsel is not ready.
In that case, my lord, extend the interim order.
On prayer of the respondents, the matter is adjourned. The paragraph, let the matter appear under the same heading on 13th March. Paragraph, the interim order granted earlier is extended till 31st March or until further orders, whichever is earlier.
Grateful, my lord. Lord,
Next
regarding
four
four
matters
matters
similar.
are same.
Deeply obliged.
Grateful, my lord.
56.
Yes, my lord. Yes, grateful.
Deeply obliged.
Next.
757.
Now, my lord, last occasion, as per your lordship's direction, they have calculated. Yes, the calculation has been done. Now, my lord, the only objection, calculation is all right. Period, they have excluded. The only objection is this, my lord. I have approached before them for accepting my tax since 2020.
Since?
2020. Immediately after the COVID period is restriction was over in 31st after 31st of October 2020. They themselves did not accepted anything. On the other hand, they considered in a manner which is not acceptable by the Honorable Court. Now they have calculated after your lordship giving much pain in the matter, all directions. I am very grateful to your lordship. Now your lordship kindly see, they have, as to how they have charged the penalty, I don't understand. One minute. Let me complete. On the penalty.
That is where I saw.
Oh.
That is the order passed on September 14.
29th of February. Yeah, just keep for whoever.
No, that is for West Bengal legislation, not for me. That is for West Bengal legislation.
Penalty has to be paid.
Now,
Specific order.
now, my lord, only thing, if I make the argument before your lordship regarding the waiver of the penalty, Mr. Debray may later on say that I am trying to enlarge the scope of the writ petition.
That is
Later on may say. It is likely if I am his place, I could have taken that point. So I can obviously.
Well, we shall comply with my lord direction.
No doubt. No.
Disposed of the matter, let him file based on the writ petition regarding that. Not your
No, this is not subject to challenge. I know it. That's why On my own, I have indicated if I am in his place, I could have taken that point. This is the enlargement scope of the writ petition, which is not permissible. I know that. But even then, I appeal to your lordship that this person already moved 4 or 5 writ petitions for getting this order, which ought to have he received the order after my lord Abhijit Gangavate passed the order for consideration of this matter. They did not on their own.
In this writ petition, you have challenged an order passed on September 14.
Yes.
Where is that order? Page 70.
Yes. Manoj, this is the order. The first order, then
September 14, 2022.
yes, I'm showing to your lordship. Oh, yes. Your lordship, kindly come to page 94.
Yes.
And man, the prayer also I have made. If I take that, my prayer was, this is the period they have to calculate without charging any penalty. But it's not my fault. All through I have made them representation, please accept my tax. Leaving the period for which I have already paid, I could not ply the vehicle. And you have put in restriction.
In the order impugned, the exemption was not permitted.
No, nothing was permitted. In the order impugned, nothing has permitted.
The representation was with regard to exemption of taxes during the
No, no.
COVID period.
Yes, a representation was made for exemption of the period for which I could not operate and the period in which I have already paid the tax.
Is for by the present calculation that has been allowed.
No, only one thing has not been done. That your lordship, can you see the calculation? In the first column, they have said already paid. This is restriction period. I have already paid this amount.
This is the calculation on 8 January 2024.
No, 24th January. 24th January, the communication has been made. Last calculation.
24th January.
Yes.
Yes.
Your lordship, can you see the first column, 1st April 2020 to 6/5/2020. This period already paid. This is the restriction period. That has to be adjusted as per the, but that has not been adjusted. And in the writ petition, I have made the specific prayer. Now, if I file another writ petition challenging this, can it not be termed as res judicata? May I put this question to myself?
Please come to the second column, the second number item, 7th May 2020.
Yes, no restriction. Yes.
Restriction period.
First is restriction, there is no restriction.
The second is restriction period.
No,
7th May to 30th September.
7th May, yes, that is restriction period.
Restriction, but total due they are showing 38892.
No, this is the restriction period from 1/4/20 to 30th September 20. That is first two column. This is due. This was due amount. They have waived this 38,892.
And then the remaining figures are no restriction period.
No restriction period. This is no restriction period is 1st October to 31st March 2021. Then 1st April to 4th May 2021. Then again restriction starts 5th May 2021 to 31st October 2021. Then again restriction lifted from 1st November 2021. And your lordship kindly appreciate that I have made representation and I have come before this honorable court. The honorable court passed the order asking them to consider my representation in I believe in October or in November. Your lordship kindly see 1 minute.
Beyond the restriction period, they have calculated your dues to be 2,66,000 and odd.
Along with the penalty. The principal amount is this. This is the principal amount. Your lordship kindly see. This is the principal amount.
2,66,688.
No, that is along with this. No. What they have done? No, madam. This is their amount, 96,304. Where from they get it 2,66,000, I don't know. Your lordship kindly upper hand, the upper period.
96,304 is from 1st January 23 to 31st December.
Oh, up to this. Up to this, yes.
These are all breakups.
Yes, up to this.
Total figure is 2,66,000 and odd.
Yes.
So you agree to this figure?
That is inclusive of penalty. Now, madam, for penalty, I am drawing your lordship's attention that I have asked them to calculate my figure since December 2020. Your lordship, can you see page 57?
Yes.
Yes, that's my representation in December 2020. Now, as they did not consider, I waited for 2.5 months. Then I moved before this honorable court. Page 63. And this honorable court, Maharaja Justice Gangopadhyay was pleased to direct them. Yes, your lordship kindly see, I therefore direct the respondent number 3 to consider the representation of the petitioner, which is that annexure P6 of the writ petition after giving an opportunity of hearing to the petitioner or is authorized representative within a period of 8 weeks from the date of communication of the order. The decision to be communicated to the petitioner by 2 weeks thereafter. This was his lordship's order. Now, they considered the matter, page 70. Nothing was in the consideration. Challenging the same, I filed further writ petition. Maharaja Hiranmay Bhattacharya delivered a detailed decision asking them to recalculate. Again, they have, and thereafter your lordship has taken up the issue. Matter came up before your lordship. Time to time, your lordship was pleased to pass the order. Now, may I put this question? Where
because in all these orders, the exemption was regretted.
Exemption or regret?
Nothing held with regard to the penalty part.
Exemption was not allowed, so question of penalty disallowing doesn't arise.
No, they are two separate issues.
Then, and only one order they have issued that they will allow me the installment for payment of this period without the penalty. But that your lordship was pleased to regret them. No, this cannot be a calculation. You calculate afresh. Then they have calculated this.
I think Mr. Debra, yes, let us hear Mr. Debra on this. Why will you charge penalty on this? Because you have exempted the restriction period.
No report any of the order.
All this while it is only with regard to the exemption.
No. Your lordship kindly see. No. First order for consideration. No. First order.
He has to go before the authority.
First order, your lordship kindly see.
He's operating there with regularity. Ultimately, the two witnesses are seen, lordship knows, or it's up to appeal court also. They fail to get any order, they have to pay. So how can the government block their revenue?
No. Question of not losing revenue. Government has to charge it.
Since this issue has not been taken up in the petition, neither was your prayer made on it.
No, prayer has been made. Prayer has been made. And this issue has been taken before the authority themselves.
Without charging any penalty. Prayer has
been made. And And
No court has been entered regarding penalty.
and your lordship kindly see.
Court also did not interest.
No. Appeal court order is something different. Your lordship has interpreted that. No. Appeal court order is something different.
The scenario is absolutely different here.
Different.
I am not going to that.
He could not pay because you did not accept.
He proved the authority that at that period of time, he is not able to fly his vehicle, submitted all the documents before the authority.
He has proved, that's why you have exempted him.
That's the exempted, yes. Exempted
That proof is not further required because on proof of that, the exemption has been granted.
No, penalty portion, I am not going. Penalty portion is statutory penalty, I don't.
The petitioner could, let us take it this way, the petitioner could not pay because the exemptions were not being permitted. Yes, you were all throughout saying that you have to pay for the restriction period also, so that we accept the remaining period. So now that you have exempted the period of restriction, why will you impose penalty? Petitioner could not pay because you did not allow the exemption. This cannot
be done.
Yes, compromise happened on the Lordship kindly direct the authority to consider his case that if he is not operating the victim for the presidency of the then they will consider against otherwise
They will not. So long your lordship has indicated, seen what the consideration they have done.
I am not with the penalties concerned, they are very much regarding tax is concerned. Otherwise,
Where is my fault? May I put this question to myself? Where is my fault? I have asked for payment. No, not just because. Not just because. I have asked for the payment of the taxes.
Other penalty you know, my specific.
I have prayed before the authority while hearing the matter by them in the written representation.
I'm going through your representation that was before the authority.
Yes, your lordship.
You have paid for exemption.
That is on December 2020.
Yes.
Then penalty was not due, period was continuing. Period was continuing. That's why I prayed for.
Further prayer for
Yes, your lordship can come to page 72, the written representation, while they heard the matter. Yes, your lordship can see page 78. Specific prayer has been made. They never gone through my representation and also my written notes of submission. Now, your lordship, can you see another written note submission?
Representation says that you could not operate. You have asked for exemption, but where you have not made a single.
Yeah, at that stage, your lordship, can you see the representation made on 17 December 2020?
17 December, there is no story of penalty.
No, 17 December, there is no story of penalty.
Even in the subsequent representation.
Now your lordship, when they heard the matter, then some period has crossed.
Even in your written submission made on page 72, you have not only the prayer you say without penalty.
No. I have said.
In the where is the in the contents? It's not there. I do not find it. Please show me. You have also said that you were restricted from flying.
Yes.
Where is the explanation for
Yes, your lordship, can you see page 77, paragraph. It starts from page 76, paragraph 9. Paragraph 9. A specific reason I have given.
Instead of sending this back to the authority, Mr. Debroy, I would like you to take instructions on this issue. Because this is not a stretching of the writ petition, it is already there.
It is already there.
Because it was not agitated.
Because they have not, because they
Because
did,
there was no earlier order, it's not that no
and
further order.
your lordship can see. Now,
It is in the writ petition itself, in the prayers, in the representations everywhere. All this while we were deciding on the exemption part. Now that that has been decided, now we are on the penalty part. There are two separate parts in the writ petition. All your instructions are with regard to exemption of the restriction period. That has been sorted out. So since there was a restriction and you did not accept the tax and the additional tax as offered by the petitioner, where is the fault of the petitioner? Why will he pay penalty?
Only the maintenance of the restriction that they take advantage of that. Taking that advantage.
In the written notes of argument also it is said that they have approached the authority for payment. You did not accept, you said no, you have to pay for the restricted period also. So you did not accept. Now that you have exempted that part, how will penalty be due? Very well, let me pass an order without penalty. You deposit the remaining amount. Please tell me the dates.
well, the date is
I said talk with the secretary regarding waiver scheme is continuing, but
waiver scheme is with regard to Bengal.
Your lordship, can you pardon me? I can give here and now.
Let him complete.
No, no.
Let's see what he's saying.
Now I talk, I talk with that.
Yes. So is he agreeable to waive this penalty also?
They can.
Senior boss is transport secretary only clarify the notification. Otherwise not.
Very well. Let them clarify.
Clarify বলতে হবে কোনটা নিতে পারবে
No, no, no. Let them clarify because the original notification.
thousands of vehicles.
I know there are thousands of vehicles.
All are pipeline.
I know.
All are
Odisha has already exempted all these big
It
vehicles.
doesn't depend on the number of vehicles. It depends on the rules. Yes. If the principle allows, even if there are 1,000 vehicles flying, you have to consider. That's why I say I will pass an order to accept it without penalty. If you want to take further instructions, you can come. Since you say that there is a
not mentioned in so likely direct the authority to calculate the penalty and to remit the penalty as the vehicle is done. That has to be proved by the authority.
What I shall prove?
No, that has to prove.
What I shall prove?
By exempting the restriction period, you have admitted that the vehicle was not plying during that period. Yes.
And during the flight, he is not denying that he is not flying.
No, 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 no. I am plying the vehicle and all along I have approached the authority for payment of tax.
For the authority, he has approached, you have not taken on the ground that you have to pay for the exempted period.
Yes, and also the penalty.
You have not accepted the amount, the money. You have also said
that is his contest. That is not my contest, that is his contest.
Why don't you take instructions and come back on this, on the penalty part? If you can show that the petitioner has any fault.
Regarding penalty first concern, then
Yes, I'll do. Third learned counsels for the
I am not standing in the way of in any case, but the taxes
it appears from the assessment of tax and additional tax submitted by the respondent authorities on 24th January 24. that the
Period.
period under restriction during which the petitioner's vehicle was not plying
No, I mean,
has been
that's principle.
exempted by the authority. Stop.
এটা তো বাদ যাবে
However, comma, the authority has
period extra.
calculated the amount payable by the petitioner, including penalty thereon. Stop. Paragraph. Record reveals that the petitioner approached the authority on several occasions for payment of tax and additional tax for the period when the petitioner was plying the vehicle. Stop. Learned counsel for the petitioner submits that the authority refused to accept the same on the ground that the petitioner did not offer to pay the tax and additional tax for the restriction period. Stop. Now that tax and additional tax for the period of restriction has been waived by the authority, comma, it appears that there is no fault on the part of the petitioner in offering to pay the taxes at the relevant time. Stop. It was the authority who refused to accept the same from the petitioner. Stop. Therefore, comma, according to the petitioner, comma, no penalty can be imposed upon the petitioner for alleged delayed payment of the tax and additional tax. Paragraph. Learned counsel for the respondents is requested to take instructions in this regard. Penalty. Yes. And it has to be explained, Mr. Dev. Please understand that. No. It's only, it is only when our conception is clear that we can instruct the authority, isn't it? We should have our conceptions clear.
I believe by this period, your lordship knows me. I never made any prayer, any submission, which is not in my record. I may forget it because of my age, but I never, which is not there, I said no.
Let the matter appear under the same heading on, Mr. Devra, 15th March should be sufficient. 15th.
No, prior to that, there is a 29th February up to waiver scheme is continued. I am trying.
Before that. So 23rd February.
23rd February is all right. 23rd February, my lord, is, I believe,
Friday?
Thursday, Friday, yes.
Please see if you can include these vehicles also in your waiver scheme so that it can be solved once and
That's the solved problem. Otherwise, the scheme has to go to, that has to be apart, but that is contemplated by the.
If it can be extended to vehicles which are plying in West Bengal.
That doesn't need
Even if registration is not in West Bengal, if they are plying in West Bengal, it can be extended.
Adjoining states have already been done. Bihar, Jharkhand, Odisha, everybody. West Bengal vehicles are not going to pay any tax in respect of that COVID period, in respect of Bihar tax, Jharkhand tax, and that no. That state government has already waived all these things. Because I have certain clients for them. I have seen it.
Let us see. Next.
758.
758, I am for the petitioner. Now, here. Oh, petitioner, na? Amra. Oh, brief it up.
Mr. Devra.
And here the issue is,
Private respondents.
and the issue is, while the extension and curtailment has been made, the decision has been taken by the authority. They have indicated in the permit itself that the approval of the transport department is to be taken. Now, in the writ petition, I have demonstrated that no approval has been taken from the transport department, no decision has been taken by the transport authority. But even then, they are forcing me to ply in the cartilage and extended period, leaving aside this thing. Your Lordship was kind enough to ask them to take definite instruction and to file report relating to this portion, whether approval of the state government has been taken or not. Now, Mr. Debray, in his last additional report, has specifically urged that no decision has been taken from the state government and it is also not required at all. Your Lordship, kindly see the report of last report of Mr. Debray.
Affirmed on 24th August.
Affirmed on? No, later on. Yes. Additional report? 8th December.
Yes.
Now, my lord, there, so issue now restricted whether any permission from the state government is required or not. What's Mr. Debray's stand? Your Lordship, kindly see. Let us last paragraph 6 of his report.
Paragraph 6, yes.
Paragraph 6. Section 88 of the Motor Vehicles Act 1988 speaks about validation of permits for use outside region in which granted. Subsection 1 of Section 88 of the said Act provides that except as may be provided, otherwise be prescribed, a permit granted by the Regional Transport Authority of any one region shall not be valid in any other region unless the permit has been countersigned by the Regional Transport Authority of other region. And a permit granted in any one state shall not be valid in any other state unless countersigned by the State Transport Authority of the other state or by the Regional Transport Authority concerned. But this is, I believe, is not concerned about, this is accepted principle. Now, Rule 102 provides an application for counter signature of the permit shall be made before the Transport Authority which granted the permit. And the said authority shall forward the same to the Transport Authority within whose jurisdiction the counter signature is spread, for subject to the provisions of these rules that the permit shall be effective from the date on which such counter signature is made. It is also not disputed. Then 88.1 on conjoined reading paragraph 8 on conjoined reading of section 88.1 of the said Act and Rule 102 of the Rules 1989. It is apparent that application for counter signature has to be made before the Transport Authority which has issued the permit in the permit using issuing authority shall forward the same to other Transport Authority whose counter signature has been sought for. In the present case, it is not the case of the petitioner. The application was made by the permit holder of route number 39A2 before the respondent Transport Authority Kolkata, seeking counter signature of the respective route permit by the Regional Transport Authority South Chobbish Parganas, and the answering respondent in turn failed to forward such permit for counter signature. Why this has been written, I don't know. In any event, prior to adopting the subject resolution on 9th February 2010, the then Secretary Regional Transport Authority Kolkata by letter number such and such informed Regional Transport Authority South Chobbish Pargana perusing consent and no objection from Regional Transport Authority South Chobbish Parganas for extension of route number 39A2 up to Gujarat. The Regional Transport Authority South Chobbish Pargana in its board meeting held on 9 July 2009 by agenda number 11 considered the same and decided to accord approval such prayer. Consequently, by memo number 6187 MB dated 21st October 2009, the Secretary Regional Transport Authority 24 Parganas communicated such decision to the Secretary Regional Transport Kolkata. This would apparent from Annexure P6, page 46 to read petition itself. However, for the sake of convenience, said memo number 6187 MB dated 21st October 2009 is annexed hereto and marked annum. So far as the approval of the Transport Department, Government of West Bengal to the resolution of 9th February 2023 is concerned, I state that no such approval is contemplated in the statute itself and hence the same is not required to be taken. It's not correct. Because the route itself is a notified route. Notification has been made by the state government. Limiting the number of vehicles and restricted the plying of the vehicle in respect to route. The originating and terminating point has been indicated in the notification itself. Now, my lord, this is in common parlance. If any authority wants to change any notification, a further notification is to be issued. This is under the general clause that I need not explain to your lordship that what is the rule, what is the all these things. Secondly, my lord, this notification issued by a higher authority. Admittedly, Transport Department, Government of West Bengal higher than the Regional Transport Authority. Now, higher authority fixes one route. No doubt, the Transport Authority, local transport authority has the power to grant permit. Where the route has been indicated, where the route has been approved. Otherwise, 68.3 CA would be redundant. 68.3 CA as per the Act, your lordship, can you see? Yes, your lordship, can you see? Motor Vehicles Act 1988, Section 68.3 CA has been incorporated in 1994.
Is the government to formulate rules?
Government to formulate the route. So, formulation of route is for the government. Now, if anybody wants to change the terminating point or the originating point, so approach has to be made with the government because he has formulated the route. Now, here, originally, the RTA in the permit itself has been written that yes, we have taken resolution. We have no objection to change this. But the authority has to be considered. The transport authority has to be considered.
Subject to approval.
Subject to approval. Now, Mr. Debra has said, no approval is given. Why? What is the reason? May I put this question to myself? There is no reason has been indicated. This is the reason. This is the car baje bhai. Bare jao, bare jao, bare jao. Argument kochi bajacche ekhane bojche. What is this? So, my lord, the reason has to be indicated. If any decision, anything has been said by the state government, statutory authority, reason has to be indicated. Now, where is that reason? May I put this question to myself? Secondly, your lordship, can you see that one notification? Yes. Yes. Your lordship, can you see page 30 of the writ petition? Ache tomar kache writ petition. Page 30 of the sheri bar korchilam.
30 is the resolution. The
No, 30 of the writ petition.
Yes.
Notification. Your lordship, can you see the first paragraph? After Salt Lake Town Station in respect of RTA Kolkata, in the manner specified hereunder, with immediate effect, the list may be altered or added to subsequently, if so considered necessary by the state government. Now, my lord, here, Mr. Debra in this paragraph 10 has written no requirement. Then this thing has to be changed by the state government. No, it's not required. RTAs are free. And another notification has also been issued in 2008. Although that is not very specific, but it indicates that. And the resolution also taken in that manner. In the permit itself, which is engrafted. Your lordship, can you see that I have shown to your lordship on earlier occasion. In the permit itself, it is written. Page 47A. It is typed copy. I have given the color xerox to your lordship because if I made it xerox, it will not be legible.
47A, yes.
47A in the writ petition. Extension of the alignment of route number 39A2 up to Bhojerat, subject to necessary approval from the Transport Department as per decision of RTA Kolkata dated 9/2/2010. And my lord, we have made one exception that has been affirmed on
49 is your objection, page 49.
no, that is affirmed on 18 September 2023. One exception to the original exception of the state government. Another we have filed two reply to the exception. First reply to the original exception, that is on 18 September 2023. Your Lordship, kindly take that.
September
Yes.
2023.
Now, your Lordship, kindly see, I have enclosed one notification of 2008, page 9.
Yes.
18 September exception. Definitely আছে তুমি এরপরে দেখে তুমি additional report submit করেছিলে. Your Lordship, kindly come to this is the notification. I am drawing your Lordship's attention the last paragraph of page 9. Whereas the state government considered no new stage carriage, contract carriage route would be granted within the jurisdiction of Kolkata Municipal Corporation area without having adequate terminal facility of both ends, which is an integral part of the particular route. Next, whereas it has been decided that greater interest of citizens of Kolkata, creation and or formulation of any new stage contract carriage which originates or touches the jurisdiction of Kolkata Municipal Corporation area need be regulated appropriately. Now, therefore, in exercise of the power conferred under section 71(3)(a) of the Motor Vehicles Act and 74(3)(a) of the Motor Vehicles in 1988, the governor has been pleased to direct until further order no new stage carriage permit as well as contract carriage permit route for all category of passenger vehicle originating or terminating or touching areas within Kolkata Municipal Corporation be issued, excluding interstate carriage contract carriage permit by the Regional Transport Authority Kolkata and other regional transport authorities, as well as State Transport Authority West Bengal, without the approval of the state government, which will consider primarily availability of termini facilities, capacity of the corridor, accommodation of new buses, environment-related problems, and other connected issues. The Government of Transport Department, however, have liberty to notify any new routes as deemed fit, considering all aspects of the matter. So, my lord, under section 71(3)(a), the notification has been issued. This on which the restriction have been imposed. So, in respect of this, the government has issued further restriction that for creating new routes and other things, this originating, touching, this permission from the state government has to be taken.
Yes.
And your Lordship can see what is the original resolution. Route was 39A2. When the route is, your Lordship kindly come to page 32 of the writ petition.
Yes.
Route is, page 32, serial number 60, route number 39. Picnic Garden to High Court, Picnic Garden to Eastern Side, Picnic Garden to Howrah Station, Picnic Garden to Howrah Fire Service Station. This is the route. Now, these are the cluster of routes. My question, operation is in respect of this. Number 3, na? Picnic Garden to Howrah Station. Number 3. Now, this route has been, and the permit has been issued in this manner. Page 25, the Picnic Garden to Howrah Railway Station. Yeah, Howrah Station, yes. Page 27, 28, 25, all this.
Yes.
All this. Achha. Now, your Lordship, can you see? Page 27, very specific. Route number 39, High Court to Picnic Garden. Route 39A, Salt Lake to AJ Bus Stand to Picnic Garden. Route 39A2, Picnic Garden Road to Howrah station. Very specific. Now, my lord, this is the route as formulated by the state government. Now, what they are going to do? The application has been made for changing the route terminus. What was that application by one alleged to be the secretary of the route? Yes. Your lordship, can you page 37?
That is the private respondent hearing.
No. He claimed himself the secretary of the route on earlier occasion. He is no longer the secretary at the present moment. Now, it was in 2006. We born in later on, in 2015. Now, your lordship, can you see what they have indicated? This is to inform you that with the operators of route number 39 and 39A2 have been operating our buses on rotation basis on permits granted by the Regional Transport Authority in different segments. In one permit number, 39A2 are flying from Picnic Garden, VIP Bazar, Howrah, via Park Circus, Mollik Bazar, AGC Bose Road, Shialda, College Street, Howrah. The entire alignment of the said route is covered by a number of buses, minibuses, and CSTC buses. Thereby, we are not in a position to maintain our buses, restricting sale of the tickets. The quantum of realization through tickets is even not adequate to offset the cost of fuel, and not to speak of the cost of manpower contingent. As a solution to the perpetuating problem, as stated above, we could earnestly request you to allow the route number A2 along with 20 buses of 39A, which were not plying since 1 year due to non-viable of the route, ply Howrah station to Bhojerat via Picnic Garden Road. Propose the extension of alignment Science City, Basanti Road, Leather Complex, Bhojerat. I request your good self to consider the request favorably and take necessary action for issuing the changes of alignment that we maintain our buses properly. Now, this representation was directly to be considered by my Lord Justice Sanjeev Banerjee in 7 December 2006. That is at page 42.
Yes.
Now, Mr. Debray was appearing.
In my name is better I release.
For petitioner.
I have to sign.
Yes.
That is better. Just now I did.
And state government, Mr. Khan. Now Mr. Khan is against the state government. I was not where, not anywhere. Asked to consider. This is the consideration.
This was subject to no objection certificate.
Have no objection certificate.
Internal communication.
Yes.
Page
Now you are
43.
also page 43. Now page 43.
That's an internal communication.
Internal communication. Now, what the decision is? Decision is necessary approval from Transport Department. Now they say approval is not required. Now this is the route. What they are going to do? They are curtailing the portion of the route. Yes. Yes, your lordship, kindly come to page 49. What they are going to now change?
This is your objection.
My objection. Change is 39A2, thereby curtailing a portion of route from Kohinoor Market to Picnic Garden and extending the said route up to Bhojerat from Darga Road, number 4 bridge crossing, and thereby asking the police authority to show cause. Now, this has been done by the authority and asking the police to stop our vehicle, the petitioner's vehicle, so that we can go there. We are challenging that portion of the order as to how this has been done. Now, in the parlance of the Motor Vehicles Act, the curtailment and extension cannot be done simultaneously. That is a precise decision of our High Court as decided by my Lord Justice Dipankar Datta. One writ petition was moved before his lordship, making prayer for this. I am handing over the copy to your lordship. where Mr. Debray was appearing for the state. It was his submission. Joseph Kekado? দেখাচ্ছি আমার this is issue is similar but not factor not this similar. The issue is that here the application was made for a portion of the curtailment and another portion of extension. আমার
Was dismissed only on that ground. That both cannot be simultaneously allowed.
Here also the same thing. Your lordship can see my fair chart that will more clear the position. Page 34, the fair chart. They want to curtail this portion of the route.
Page 34.
Page 34. Vertically.
Yes.
Now, from Picnic Garden, 39 bus stand, Kustia Mall, Kohinoor Market. This will be curtailed. Yes. Up to Dorga Road, it will be curtailed. From Picnic Garden to Dorga Road. The bus will move up to Lady Garden, Lady Brevon College, and then it will move to that area. Hojerat and other thing. So the termini is going to be altered.
Yes.
And my lord, section 80, subsection 3. And this was given to us on 2018 itself. 18 or 20? 20. Oh. Up to 18 it has been given. Now you will also kindly see 80 subsection 3. Now there is no preactable. What was given? Yes. Subsection 3, an application to vary the condition of any permit other than a temporary permit by inclusion of a new route or routes or a new area or by altering the route or routes or area covered by it, or in case of a stage carriage permit by increasing the number of trips above the specified number maximum by variation, extension or curtailment of the route or routes or the area specified in the permit shall be treated as an application for grant of new permit. Then if I take this 80 subsection 3, then it will hit by 2008 notification. You also kindly remember 2008 notification says that for creation of any new route, permission from the state government has to be taken. This is as per the statute, a creation of new route. Then, provided that it shall be not necessary to treat an application made by the holder of stage carriage permit who provides only service on any route to increase the frequency of the service, so provided without any increase of number of vehicles. Provided further, in case of variation, the termini shall not be altered and the distance covered, the variation shall not exceed 24 kilometers. In case of extension of the distance covered by extension shall not 24 kilometers from the termini. So extension is 24 kilometers from termini. And both are not permissible. That has been held by Mala Justice Dotto. Both are not permissible. So, if both are not permissible and as per 80 subsection 3, if it is a creation of new route, then it is also hit by 2008 notification. No, 2008 notification. Page 67 writ petition is there. That is restriction for entering into Calcutta. That is not restricted zone. That is there. That is there. Apart from that, this 2008 notification just now I have placed before your lordship. There also the state government has categorically says that under section 71(3)(a) of the Motor Vehicles Act, government has been pleased to direct that until further order, any route originating or terminating or touching the areas within Kolkata Municipal Corporation be issued, excluding interstate cash contracted by Regional Transport Authority, Kolkata and other regional transport authorities, as well as the State Transport Authority of West Bengal, without the approval of the state government. So, but as per this section, this is the creation of a new route, because this is inclusion of a new route or new area by altering the route or routes.
Where is the order impugned?
The order impugned ta kothay? Oh, order impugned is here. Yes, this is the order. Individually, they have served everybody. Yes. Page 61. No, that is issue করছি না। Page 61. Resident Secretary route number S281, route number 39A2 appeared before the RTA board meeting and they are duly heard. RTA board discussed the matter and decided to issue notice to Secretary RTA Kolkata within and end within 7 days to the permit holder of route number 39A2 for endorsement of existing route alignment. Now, individually they have given notice, RTA Kolkata region. Page 62, 63, 64 onwards.
These are notices. These are notices.
These are notices. And then we have come before approach your lordship. Lordship, please to pass an interim order staying the operation.
No. Interim order.
No interim order, no. Your lordship was pleased to direct them to submit a report.
Notices were issued for endorsement of existing route alignment.
No. Gujarat to Howrah station, which has been decided by them to you are to apply on the basis of that. Gujarat to Howrah station is not the route. Route is this.
Yes, according to the page 32. Is that
Page 32. Route is this. That's not the route.
That's all your submission?
At the present moment. Let me hear Mr. Debra what he is saying.
Shall we hear Mr. Debra on the next occasion?
No.
Since other matters are all waiting.
No problem. I have no problem. I have no problem. I have also other matters later on. Very well. I have no problem.
Attorney counsel for the petitioner.
Only Saraswati call করতে।
Let the matter appear in the same heading for matters for further consideration.
সেই আমি সিদ্ধান্ত না এলে আমিও আসবো।
Already
12th March.
Yes. I was praying that after this week of Saraswati Puja, because my clerk, his clerk will not be available during this period.
12th March.
Well, before 9th March,
Will you not be there?
Between 9th to Sunday.
Then
Virtual mode.
Very well. 8th. Virtual mode, it is difficult to submit, isn't it? With all the documents and.
The documents are here.
No, your lordship was made in 12th March. তুমি ভিডিও কবে? শেষে মার্চের শেষে। Oh, then your lordship can take up on 5th of March.
8th March will be all right.
8th March, no problem.
8th March, no problem.
March. Mr. Khan is also appearing in this matter.
Yes, Mr. Khan is also appearing.
দুটো আছে।
Very well.
That is priority.
That is priority.
Myself also my.
Gunjan Sinha মামলা কোথায়? বুঝো?
Before yesterday also my.
না। না? এখানে রাখলাম তো। কোথায়? না না কিছু রাখলাম।
30, I think, on
তো
the.
চাপা দিয়ে আসছিল। চাপা দেওয়া আছে? কত নম্বর আছে?
Please take care.
He is not taking care.
798,
Please take care. You're all assets to the court.
কেন?
You have to take care.
58 এইটা কি 98? না ওটা
Last week of that is police.
ঠিক আছে চল।
760.
Yes, 760.
No, this is my matter. Your Lordship, kindly.
Report. Received.
Here only the issue is that the director and the assistant secretary. Who is the assistant? Yes. Who is assistant secretary is that is at page 40. This is the additional secretary, page 40. There the additional secretary opined that I am also directed to inform you that was second paragraph. Relevant materials with regard to the pending technical expertise, that is the issue. And they are the they have.
Mr. Devra, a report was called for from you. So please come back with the
Earlier, I was not there, madam. After long time, but I was there.
Well, that's right, that's right. Your Lordship has directed to
Told me that,
take the brief
instruction, but
on the last occasions, and that's right.
So let him come back with the report.
Mine.
Learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 1st March.
My lord, Mr. Pratim Dhar is appearing on behalf of the state respondent, my lord.
Mr. Devra is appearing.
She has already entrusted by.
Oh, okay.
নাম দাওনি তো?
761.
প্রতিদিন ধর হ্যান্ড ওভার করে দিয়েছিল চিঠি আর all ordered questions.
My lord, in 761, Learned Advocate Kakuri Dotto is appearing for the petitioner, my lord. She wants to file an exception to the report filed by the state government. So
She.
she is engaged in another court, my lord. She has requested me, my lord. Actually, she is engaged in election result, my lord.
Counsel for the petitioners seeks further extension of time to use the rejoinder as sought by Acharya Agrawal. Paragraph, let the matter appear under the same heading on
কোথায় আমি আছি? হ্যাঁ, আমি আছি।
8th March.
তাহলে হবে না, তাহলে হবে না, স্যার সোমবার হোক।
762 and 62 are my madam.
Yes.
But in 762, Mr.
Shane is appearing.
I've already engaged on the. Can take it up on Monday.
Adjournments have been sought by the petitioner. Not today only?
Only not today.
Not today. Both the matters?
Both the matter, 762, 63.
Not.
I've submitted my report also.
Yes, yes. Report we have received, we have, everything has been done.
It's ready for hearing.
Monday. Monday তো আসবে নেই তো।
Monday.
Yes, sir.
Have you served?
Yes, yes.
You're okay?
Madam, the short question involved in this application is that I received a notice on 23rd February that my car emitted pollution at Victoria. That is only. That it is written, your vehicles bearing annexure P1, page 15. Your vehicle bearing registration number such and such was found violating at air pollution limit at Victoria on 10th February 2023 as said as per rule such and such as shows below. You are requested to produce the vehicle below
mention RTO ART office within 7 working days after necessary rectification along with freshly tested PUC certificate, otherwise requisite fine under such and such. My lord, on the very day, my car annexure page 16, kind car page 16, my car, I was blacklisted.
On the same day?
Oh, same day. If I same day, but
No. This is 13th February 2023.
no. On the 13th February, 10th February. That is 10th February.
Page 15 is 13th February.
13th February, but 13th February. But it was blacklisted on 10th February. Next paragraph 16.
Yes.
Dated 10th February before
Issuance of notice.
notice. My lord, come paper page 17. 8/12/2022 pollution under control certificate from the authorized agency of the motor vehicles. And it is supposed to expire on 7/12/2023.
Yes. Oh, this is valid up to.
But on 26/2/2020, I gave a notice to the department. Please inform me what actually how could this is I have never heard even that there are thousands, hundreds cars running, flying through the road.
And you have a valid certificate.
Yes. Well, kindly see page 3. Page 18. It's page 17. Only 2 months back.
Yes,
Well,
Mr. Dev.
well, another thing, my lord. Well, this is my lord. This is not the my lord. This is why this sort of notice they are sending to various people. Even a friend of mine, he lives in Salt Lake. His notice was issued that in Barakpur your car was emitting pollution. Well, because this? How could the official seeing the pollution from the smoke coming out from the car, hundreds cars are going without physically inspecting the vehicle. Admittedly, there was no physical inspection. Records say Victoria. Where is this? Victoria? While my car was inside the Victoria. At what time?
Let us hear the.
My lord, I have also faced same thing.
I think this should be recorded.
Yeah, I have to pay 10,000.
Well,
This is the camera. On camera, there is a pollution level, but under the pollution control code, fixes the camera. They send it to the department.
Where is that camera fixed?
That is
Red road.
how could camera detect my pollution?
Camera.
How can I not even see it?
There's a speed checking camera, but not pollution.
Speed checking. But physical inspection should be there.
Sir Devraj, we have checked it into camera. Why? I do not know. I have nothing.
And you have a valid certificate also.
Yes, everything was done. In spite of I have to, and within 1 week, if I approach them, then they approach them with this pollution certificate, then they remove. But immediately go to message.
In person.
Put message.
No, but this should be stopped.
But I have not
It is blacklisted on this ground.
On the same date.
section of the division bench as well as pollution control code. This is not my.
Who knows that?
Yes, in terms of the division bench, this thing is happening.
No, my lord. There is a Supreme Court judge also there.
Please, sir. What is the division bench order?
Division bench,
Let him come back with instructions because this needs to be stopped.
Yes, my lord, this should be stopped.
Otherwise,
My lord, many people.
Director, transport department to take steps.
No, you say there's a division bench order. That's why I'm
No,
stopped.
that is why, Lord, they can print out everything. We can approach, we can appear before them.
No, he doesn't.
No.
I'll set this aside.
My lord, question is how could without physical examination of the car, by seeing the smoke, one can detect this car is emitting air pollution.
I can take it.
Will you come back next week with an instruction?
Yes.
My lord, this should be stopped. Many people are getting harassed.
Let's see, let me come back.
Next Friday.
Next Friday?
Otherwise, my lord, there is a holiday.
Oh, yes. Come back next Friday.
If I back with
Learned counsel for the petitioner subjects.
Where?
The petitioner submits that
আমার একবার করেছিল তখন আলাপন ছিল ট্রান্সপোর্ট সেক্রেটারি তো আমার সঙ্গে একসঙ্গে আলাপন তো কিছু ভালো করে দিয়েছিল
by the assistant director within bracket technical comma PVD Kolkata on 13th February 2023. 13th February 2023. Stating that his vehicle bearing registration number WP061 6482 was found violating air pollution at Victoria on 10th February 2023. Stop.
It should be stopped.
The petitioner was directed to produce the vehicle before the RTO/ARTO office within 7 working days, along with freshly tested PUC certificate.
That is through SMS. Through SMS. That is not through SMS.
So,
No. In my case,
It's through SMS.
No. The petitioner learnt that the vehicle was blacklisted by the Salt Lake ARTO West Bengal.
No, but in my case, my mail is later.
With effect, I'm not recording. With effect from 10th February 2023. Stop.
23rd, কারণ date ছিল 23rd February.
The pollution certificate of the petitioner was valid up to 7th December 2023. Sorry. Paragraph, learned counsel for the respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 16th February. Next Friday.
It should be stopped, my lord. Many people are getting this letter. A friend of he is in London, his car is under lock and key, also get it.
But telephone, I heard that in terms of the order was by.
Ma, this is kind of
I have to go through the order.
my lord, this is not for extortion of money. That is.
Does that need to be said?
No. If Mr. Chakraborty appeared within 7 days, that's a good.
Why will he appear?
Why? No, but why? Because 2 months back, my car has been examined. There was no default in any time.
Please show me the orders under which the authority is doing this.
Well, another thing, this car I never used. I use another car because suddenly this car is received there. I just I bring Abio to the High Court, but I never bought this car to High Court. But this has received it.
Please come back, please.
Oh my God.
Next.
765.
Who is appearing, Mr. Mukherjee?
16th February.
Further, your lordship,
Yes, further instructions were
yes,
come.
further instructions, because that has not been explained. 50
And
declared
20.
by the notification, subsequently say therefore
20.
22, and the numbers also given. My lord, on that basis, 28 yet to be filled up.
The 29th May notice also.
Yes, an inviting notice.
So Devra, you wanted to take instructions in this matter. No instructions. Mr. Mukherjee, let there be a date. Yes, Devra. On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 4th March.
So this is my CAN application. Lordship, on the last occasion, it was adjourned as my learned friend appearing for the state had said that he had not received a copy of the CAN application. Lordship, I've served a copy on the state respondents as well. So I'm seeking for recalling of the order dated 16th of October 2023, majorly on 4 grounds. A, suppression of material facts. B, that the matter was taken up by the urgent determination without issuing any notice.
You wanted to use an affidavit against.
Lordship, my learned friend has filed an opposition.
Received a copy?
Yes, Your Lordship, I have received a copy. I am not using a reply.
May I?
Are you submitting a reply to this?
No, Your Lordship, I will not be using a reply.
Mr. Debra, have you received a copy of this application? Can?
Lordship, I have served on it.
Can one?
So I've served a copy. I'm carrying the receipt as well. So my recalling application is basically on 4 grounds. I am for Tata Capital.
The matter is still pending.
Lordship, the writ petition is still pending. My recalling, I have a CAN application.
My contention in this writ petition, only, let me.
Lordship.
My contention in this writ petition, the vehicle has been under a hire purchase agreement, was with the respondent Tata Finance. Now, my lord, after the death of the registered owner, the vehicle has been seized by the Tata Finance. On the grounds, the default was there in making the payments. Now, my lord, it has been sold to someone. And while the proceedings of selling, the procedural laid down in section 51, subsection 5, as well as the central motor vehicles rules which contain, that has not been followed by the authority. My lord, Justice Chaudhary was pleased to pass an order to pay the sum of the installments and an interim stage so that the vehicle cannot be sold. Now, my lord, they comes out with this application saying that it has already been sold. This is there. For that reasons, if I even pay, assuming, then the vehicle is not there. This is they have admitted. So my intention there is nothing. Only thing is that whether the procedure of selling, which has been enumerated in the acts and the rules, central rules, whether it has been followed or not. This is the only question.
No, he alleges suppression of material facts.
Lordship, there was a section 9 preferred by my learned friend.
You are
Tata Motors.
Tata Motors.
Financials. Lordship, there was a section 9 application filed by my learned friend way back in January 2021. Lordship, I have annexed that application. That is at page 26 of my CAN application. So before the district judge Birbhum, this was not disclosed in the writ petition. And that section 9 application was further then dismissed on 29th of September 2021. So my learned friend had taken his chance way back in 2021. And the vehicle was auctioned only on 31st of August 2022. That is after a year. And thereafter, Your Lordship, my learned friend's client had only issued a letter on 22nd of September 2023.
Where is you've annexed the order also?
Your Lordship, dismissal order I haven't. Your Lordship, the application is there before in my application at page 26. Your Lordship, I could not lay hands on
It's
this.
there, but say that it has been.
It was dismissed, Your Lordship, but I do not have the order. It's not annexed. I do not have the order, but
Website, it's not.
Lordship, I did not, my client could not have accessed it. Your Lordship, I'll try to get it. But Your Lordship, I had filed this application on the basis of the documents I had.
Observations need to be looked into, isn't it?
Lordship, it was dismissed for default.
Or for default.
Lordship, they did not pursue it.
Okay.
Now, Your Lordship, the vehicle was auctioned in way back in 31st of August 2022, and then I had sold the vehicle on 20, and they had come up with a representation on 22nd of September 2023, after a lapse of 1 year, and after the Section 9 being dismissed. So they had tried their luck before the arbitration court, that is under the Section 9. And thereafter, this 23 letter is just an eyewash to create some urgency, and then they move the urgent determination without giving any notice to me. Now, in the meantime, what has happened is, Your Lordship may kindly take up the impugned order and why I am seeking modification of that. Page 16 of my application. So let my learned friend show that.
Since you have not started on merits as yet.
Lordship.
Today there's a 3:30.
Lordship.
So I think let us not start the matter. I'll deal with it on a single day.
Lordship, I have just 2 minutes to.
Lose continuity actually, isn't it?
Lordship, I have just 2 lines to show. If Your Lordship so desires, I can come back. Lordship, page 16 is the impugned order of which I am seeking the vacating. 16th of October 2020.
Go through the order. It's a longish order.
Lordship.
So here it says it is going to transfer.
Yes, Your Lordship. Whereas I had already transferred, and in their writ petition, Your Lordship, at paragraph 8, they have already averred that they got to know that it's transferred sometime in the month of August 2023. And after this writ petition was filed.
They have stated that.
Yes, Your Lordship. May kindly take up paragraph 7 of the writ petition. So the petitioner states,
Give him.
page 7, paragraph 7. Your Lordship, the petitioner states that sometime in the month of August 2023, petitioner received information that the respondent number 5, that is the applicant before Your Lordship, sold the said vehicle and the ownership also transferred by the respondent. And thereafter, they make that representation.
But still suppression?
Your Lordship, this Section 9 application, that is the suppression. That they have not disclosed because they had tried their luck before the arbitration court. They did not obtain any order, which was subsequently dismissed for default. Your Lordship, so they were very well aware that they had no option, no chance. And therefore, this writ petition is nothing but a circuitous way of getting back. And Your Lordship, when they were aware that this order that there has already been a transfer, Lordship, when the learned judge was recording this order, Your Lordship, only the last paragraph, page 18, last paragraph.
Yes.
Your Lordship, I am just reading the last 3 lines. Yes. In the meantime, the finance company is directed not to transfer the registered owner in favor of any third party for a period of 1 month. Whereas, Your Lordship, they themselves state that the transfer had been made before. So, Your Lordship, this observation could not have been made. This injunction could not have been granted upon me. And let my learned friend show that any notice was served upon me before moving it before the urgent determination. I had no notice that this was being moved. Otherwise, Your Lordship, I would have apprised the court that the transfer has already taken place. Your Lordship, this is after a delay of almost 1 year. 2021, they filed their Section 9. I wait for 1 year. 2022, I sell the vehicle. And they come up in 2023 with this writ petition. There was no urgency at all.
So ownership has been transferred?
Lordship.
The entire transaction is over?
Lordship.
That is your submission?
Lordship. So this injunction order today as it stands could not have been passed against me. And especially without hearing me, Your Lordship. Subject to correction by my learned friend, there is no document on record to show that I was served with a notice that this matter is being taken up by the urgent determination. Otherwise, I would have apprised the court of this. So today, for no fault of mine, I am suffering an injunction order, which later my learned friend will come and say that I have been contempt.
There is a condition. The condition is that I have to pay.
Unfortunately, you did not serve the Tata Motors at all in the writ petition.
Writ petition? Yes, I have served.
Lordship,
My lord,
the
your lordship,
service.
yes, I have everyone service.
I can
Notice,
see only the service on the state.
Lordship, the notice for notice for mentioning, Lordship, notice for mentioning before the urgent determination.
You received a copy.
I'd received the copy of the writ petition, but when they moved this matter, Your Lordship, I was not given any notice that it's being taken up by the urgent determination because the regular bench was not sitting. So I did not have any opportunity to address the bench.
May I?
Very well, Your Lordship.
With short submissions. So far as the interim order, which has been passed by the earlier today, because of his admission, it now has become incomplete. Very. It is my contention in the writ petition is altogether different. Whether the procedure followed.
Have
by
you
the
stated the
authority.
section 9 application? It's connected. You have suppressed the section 9 application in the writ petition.
Section 9, but that cannot say.
Please come back, Samar.
I will.
Counsels for the parties, paragraph. Can order, can 1 of 2023. Affidavit in opposition submitted on behalf of the senators. And respondent number 5. So respondent number 5 is taken on the file. Paragraph heard learned counsels for the parties. Paragraph let the matter appear under the same heading. 12th March.
Lordship, any day. Grateful.
Since nothing is stopping anyone from any kind of action at all by this order.
Great.